That is what I was saying, Millard. Till the disposal, of course, subject to what Mr.
Anyway,
Mitchell said.
so it's better you take.
But kindly hears me out, Millard. Kindly hears me out.
Yes.
Till the time.
Yes.
Till the time.
No, I'm opposing to this. There is no point, Malad.
Till the time.
This
application is heard out, which of course is going to take some time because we will have to substitute and bring on record the new heirs.
So you do that expeditiously.
Let there be, Millard, a neutral receiver appointed by a lordship.
Very well, I shall consider that.
No, Millard, there is one difficulty.
Come after 7 or 8 days, you take
one difficulty, Millard. It is not that easy because there are a lot of branches. Let Mr. Mitro consider what I am saying, and then your lordship can, Millard, kindly pass an order. What I am, Millard, humbly beseeching, let there be a receiver appointed who will collect the rent. Why? Because the last rent collected from all the tenants is in March 2024. Now the tenants, Millard, if they start depositing rent with the rent controller, then it will be a very big difficulty.
You have waited for so long. Let this
application.
You wait for 7 days.
Waited for 7 months.
Let me consider your application. In the meantime,
my humble submission,
interim reliefs can be granted.
No, Millard, my humble submission, your lordship will kindly consider is.
So at present, you are representing whom?
Millard, at present, I am representing Mr. Masood Duple, who is the son of the erstwhile receiver. Be that as it may, Millard, I am requesting for your lordship to appoint a court-appointed receiver who will collect the rent in the meantime. He will keep the rent.
You just wait for 7-8 days. I'm keeping it after 7-8 days.
We will, Millard, try, but I don't think so. This was any prejudicial to the interest of anyone, because even they are not collecting the rent.
You are unable to, no. Take steps with regard to this bringing on the record.
I will definitely try.
If you are unable to do it within 7-8 days, I shall definitely consider.
Only two things, Malad. This application was filed in October. The plaintiff, knowing fully well the parties have expired, have gone ahead with an absolutely incorrect cost title. Now, this application was kept pending for 7 months, which cannot stand for 7 weeks, 7 hours, because it's absolutely incorrect cost title. I don't know how the department accepted with this cost title.
Please record an order.
Now, only one thing, Malad, I have 2 new vokalatnamas with the change advocates, Malad, with the amended cost title, because I have taken inspection. Amended cost title, as of now, the new vokalatnama is ready.
See, the earlier order is concerned, that is 1/7/2014, that is carried out. Okay.
No,
earlier order of
vokalatnama.
Yes, that you file it.
That will leave be given.
Yes. Learned.
And one thing I was submitting, Millard, lot of hue and cry regarding the cost title. Lordship sees the order of 5th of May 2022. Kindly sees, Millard. This is, Millard, what created the confusion in my most humble submission. Because
from that order,
Millard, the same old cost title is reflected even in the orders passed by the court.
That has to be
so
corrected.
It is only after your lordship helped us that we have come to know about this defect. Otherwise, orders kept on were passed on the old cost title.
Yes, learned advocates for the parties are present. Peruse the report submitted by the registrar original side. It is stated by the registrar that amendment in terms of order dated 1/7/2014 passed in GA number 1119 of 2014 has already been carried out on 9/1/2015. Stop. It is submitted by the learned advocates that the rent of the suit property is not being collected
from March 2024.
From March 2024. And in the meantime, some of the parties to the suit has already passed away, for which steps are to be taken for filing necessary application for substitution. This court adjourns this matter. This matter stands adjourned for a period of 1 week to enable the parties to take necessary steps to file the application for substitution. Another interlocutory application.
Will the leave be given, Malad?
If necessary, yes. Leave is granted
to defendant number 5F as per the new cost title.
To the defendant number 5F.
Substituted defendant.
Substituted defendant number 5F.
5F and 5G.
And the substituted defendant number 5G to file the vokalatnama.
And
Let this
but I
matter,
also obtained a certified copy of the plaint.
No,
because-
Millard, I was making this submission. Let this be a joint submission, Millard. Rather than obtaining a certified copy, kindly permits our advocate on record to obtain a photocopy because the 7 days time, Millard, otherwise certified copy will take time.
okay,
Kindly give us-
necessary inspection and photocopies of the plaint may be obtained by the
I'm deeply
learned advocates. Let this matter appear on 29.
But I was just any day other than
Other
20.
than 29th. That is
27.
also joint prayer. Millard.
Any day other
27,
20, yes, yes, any day other than
27,
29.
8, 2025 under the same heading.
No,
It
but
would have-
only thing
would-
which is troubling, Millard, this GA9, the cost title is wrong. So even if any order is passed, certified copy, obtaining a certified copy cannot be. So GA9, any event has to be withdrawn because we cannot amend a
So
petition.
come on the next day.
We cannot amend a petition.
This cannot be a joint prayer, Millard. I'm opposing to this.
Come on the next
We will
day.
see. Your Lordship has abundant power, Millard, to
No.
rectify these errors which are bona
Then
fide.
has to be done.
Which are bona fide. We'll do it.
But
Millard.
you see, the-
My lord,
the
power has
application
to be
for
done then.
substitution has to be made.
We will take steps.
Yes.
We'll take steps.
Because we cannot obtain a certified copy on a wrong cost title.
Right.
If the order is
Yes,
passed
in
on
the
a-
meantime, if you have taken out application, you mentioned.
But even
it
my
would have-
learned friend's client is free to make an application for appointment of a receiver and
Whatever
ask
it
for
is.
interim reliefs. He has the updated cost title.
Whatever it is, you do the needful.
Yes.
Yes, certainly, Millard.
When Mr. Banerjee's client is doing, let him do it.
Yes. all
Yes,
the-
yes.
I'm deeply obliged, Millard.
Obliged. The leave হয়ে গেল photocopy নেওয়া order হয়ে গেল ব্যাস আর তো কিছু লাগছে না obliged.
Item number 3.
But this is a matter which I do not know how can it appear in the list day after day. Your
Yes,
lordship has been.
Lordship, I am
see,
representing
Your
the
lordship,
plaintiffs.
The question is, on the earlier occasion, probably an application was moved, an order was passed thereafter.
Yes,
it
your
was
lordship.
No,
submitted.
no, before that, your lordship will
Your
see
lordship,
the.
So GA
Lordship, kindly
29.
Lordship,
So
kindly,
GA, now the question is, you have filed GA 29.
Kindly, well, me, your lordship hears me.
Lordship
No.
kindly allows me to speak first
Yes,
because
yes,
your
what
Lordship has
you
recalled an
say?
order.
GA 29, you have filed.
Yes, Lordship.
Yes, the suit. Kindly,
The,
kindly.
the suit is very much existing.
Your lordship will kindly hear
Your
me.
Lordship, GA number 28 was filed in the year 2023. Your Lordship kindly sees page 109A of my application.
But will your lordship first inquire whether the suit is pending? Kindly hear me. Order to the. Your lordship has seen the orders.
Your Lordship,
My junior has.
Okay, where is the disposal order of?
Yes, it was all placed before your lordship
So
on the
let me
last
see.
occasion.
Let me see the disposal order of the suit.
The final decree.
Yes, yes, yes.
এই ডিগ্রির কপিটা বার করে দিন অর্ডারটা দাও যেখানে আগের বার রেকর্ড হয়েছিল মানে your lordship will see your lordship's last order
Yes.
7th of July.
No, no, maybe, but let me see the decree
Yes, it was
which is
placed before your
passed in
lordship.
this suit.
देखिए Yes, your lordship had seen the kindly comes to the decree page 5 bottom. Kindly come to page 5 last 3 lines. And upon reading the preliminary decree dated
Which page? Which page?
page 5,
5 of?
the decree, final decree. ছয়, সাত, আট,
No,
8 lines.
where is the certified copy?
I have the copy. I do not know. I had given a copy. All the bunch of orders and decree into the. And a Xerox
It is
copy.
difficult to ascertain from here.
Your Lordship, there are still issues to be decided upon even after the passing of the
No,
final
first of
decree.
all, I have to satisfy whether the suit is still surviving or not.
Your Lordship, in the
Well, your lordship will kindly take my copy. My copy, your lordship will take. I do not know. I
your
have
Lordship
given a-
kindly allows me to submit.
I will allow you to submit, but whether there is any scope to submit,
Yes.
that I have to see.
Kindly see, my lord, from this page. Page 5, bottom, your lordship will see 8 lines from the bottom. দেখি আর পেয়েছেন না আমাকে কপিটা দিন আমি বলি। পরপর সব অর্ডার গুলো দেওয়া ছিল। একটু দিন যাচ্ছে। My lord, your lordship is seeing from the bottom, lord, may I just place, and upon reading preliminary decree dated 17th of September 2002, and upon reading the report of the Commissioner of Partition, Mr. Shondendu Ghosh, advocate appointed in this suit by an order dated 7th of January 2004, it is ordered and decreed that the said report along with the proposed scheme of partition as suggested by the valuer surveyor, which is a part of the return filed by the learned advocate Commissioner of Partition, with all things therein contained be verified and confirmed and duly observed and performed by the parties according to the tenor and meaning thereof. Next line. And it is further ordered and decreed that the partition suit as regards the disputed properties, being the properties mentioned in the plaint, particulars whereof are set out in Schedule A hereunder written, other than those mentioned in paragraph 3 of the plaint, particulars whereof are set out in Schedule B hereunder written and hereinafter referred to as the suit be and the same is hereby dismissed. So there is a final decree in respect of one schedule of property, final decree of dismissal as regards the other schedule of property. Now your lordship will see the executing court's order. Kindly see এখানে একটা order আছে দেখুন 9th of March 2016. Yes. This decree has been fully executed to the extent that the suit was decreed. This is the executing court's order. Everything has been recorded. But I do not know how department is accepting the petition.
That is because your
Well,
lordship, in
well,
this part where the
Maybe
disputed
yes,
properties has been dismissed, I say that it has not been dismissed because none of the properties have been dismissed.
They have challenged the final decree that has failed. I'll show your lordship from the
It
order.
is still pending. That is why lordship in 2023, an honorable
Let that be
coordinate bench has
decided.
allowed an substitution application. The defendants chose not to appear.
Court once, your lordship will find that. 9th of March 2016 order your lordship has found. Kindly see. The law which is settled, kindly permit me to read this. Law which is settled is sought to be unsettled by the contesting parties, inviting the executing court to travel beyond the decree. There is no quarrel to the proposition that the executing court has to confine within the precincts of the decree and cannot travel beyond. Main contesting party in the execution application is the plaintiff, that is my learned friend, who filed a suit for partition and separate possession of their shares to be declared by the court. It is not in dispute that large properties from subject matter of the suit claiming to be joint properties of the parties. Kindly note, court passed a preliminary decree on September.
So are you not aware of this order?
Yes,
If lordship kindly allows me
Yeah,
to submit, then I,
It's better you do one
Yes,
thing. You
yes.
serve a copy upon Mr. Sen. Let it.
lordship already served,
What?
already served.
One copy of this J, you give it in writing, whatever is
But
necessary.
how can a GA be filed?
Lordship,
Very well.
lordship
very well.
already
Yes, I
served.
got an order.
But GA
I'm not passing any order.
And
Let
lordship, I am
copy of this application, GA 29 of 2025.
already,
Please be served upon Mr. Sen.
But I have no wakalatnama now because my junior cannot take a wakalatnama because there is no suit.
Because you are submitting, I'm permitting you to appear.
But let it be
Yes,
served upon my junior.
The
But only
learned advocate is requested to accept this application without prejudice and come ready with the instructions. Let this application GA 29 of 2025.
may I submit
Yes,
this?
yes.
Lord, once your lordship accepts a GA in a disposed of suit,
Yes.
it is not disposed of.
then-
I oppose this, your lordship.
otherwise,
Your lordship has referred me an
The
order.
matter as to whether the suit is disposed and whether the court can pass any orders is kept open to be decided at the time of hearing. This
I'm
is
grateful,
without
your lordship.
this is without prejudice to the rights of the parties.
Grateful.
may I submit this, my lord? Your lordship will first decide, keep the
Yes,
matter.
yes. You just come with, you peruse the application.
No, there is no question of perusing, my lord. May I say this?
You see, he has filed an application.
Constitution application.
Your
Whatever
lordship,
it is,
Where?
you give it in your opposition enclosed.
I cannot give an
your
opinion.
lordship, on
Your lordship will
2023,
kindly-
they chose
I
not to
will
appear.
find a compilation of the orders
Very
just to show that the suit has been disposed
Very
of.
well, very well. You serve your copy.
Your lordship, let them file an affidavit in opposition.
File an affidavit in opposition in a disposal.
Yes, when will
It
you
is
come?
not disposed of.
Will you come?
But next week,
Let this matter appear on
But the matter was kept today only.
7/8/2025.
Your lordship had fixed the matter on 13th on 2nd. Defendants were very well aware. They chose not to appear on 13th. At the time of mentioning, they came and prayed to your lordship to recall the order. And your lordship, with the deepest of respect, an order that was passed in open court had been recalled in her absence. Your lordship, we were not allowed an opportunity of being heard.
Kindly see the order of 7th of July. There, my junior had submitted that suit is already disposed of, is also requested to come with necessary instruction.
Requested to come with instructions. It was not settled.
So it was already, first that issue has to be, how can my learned friend file an application?
That
On
is why
We have filed an
July,
application.
I have kept the issue
They
open.
have also given time to take instructions and come. How?
We have come prepared.
Your lordship will call for a report from the department first. Otherwise, this application
No,
cannot
let
be
me
accepted.
hear you. Let me see the compilations, okay, on the next day.
Your lordship, how a coordinate bench passed an order in 2023? This is a question I asked myself.
Say about the application.
An honorable coordinate bench has allowed a
Please
substitution
come with the
application.
necessary compilation and you submit on the next day. I have kept it on 27/8.
Grateful, your lordship.
But it is only a kindly, may only
Item
a
number 4.
question whether the suit is pending or not. That your
Yes,
lordship will
yes,
decide.
yes.
Very well.
But
Yes,
kindly-
yes, that is, I have kept it
Very
open.
well. Not, but the application will not be considered. Or your lordship will determine whether the suit is pending or not.
If it is not pending, there is no scope. If I am satisfied this
That is
book
what
is not
I'm
there, it will go, entire thing will
That is
go.
what I'm
Your lordship, I am humbly praying to your lordship. On 13th of August, your lordship passed an order in the morning, and your lordship recalled that
Yes,
at the
now
time
we
of
shall
validity.
hear Mr. Sen and
Your
both
lordship,
of you,
I am
and
only
then I shall decide.
your lordship, I am only beseeching your lordship to kindly allow that order also to be uploaded, which your lordship passed in the
No,
morning.
I have not signed that order. That is why I
Your
recalled
lordship
it.
had pronounced the order in open
No, no,
court,
no,
your
no,
lordship.
no. Court can recall order unless it is signed.
Grateful, your lordship.
Item number 4.
Item 4.
Item number 4.
Okay, not today.
Item number 5.
Lordship will allow me to appear online. I'm appearing for the plaintiff in this matter, my lord.
Yes.
On the last occasion, your lordship had passed an order on 7th of August directing the joint commissioners to appear with the report.
Yes.
My lord, your lordship will take up the decree which was passed on 24th of July 2014.
Joint Commissioner present.
My lord, all the advocate on records are joint commissioners in this
Yes.
application.
My lord, the advocate on records for the defendant number 1A, 1B, defendant number 2, defendant number 5, 6, 7, and the plaintiff. They are the joint commissioners. My lord, the joint commissioners, a letter was written by my advocate on record to all the advocate on records of the parties. None of them have responded to that. My lord, your lordship, the preliminary decree was passed on 24th of July 2014. Thereafter, on 13th of May 2015, the preliminary decree was modified. My lord, thereafter, by your lordship's order, a valuer was appointed. That valuer's report is there on record. Now, the joint commissioners have to take cognizance of that valuation report and file their report, my lord. That is the only part which is pending in this suit. Your lordship will give a direction to the joint commissioners to sit and consider the valuer's report and prepare a report and file before this court, my lord.
Yes, you are one of the joint
My lord,
commissioners.
I'm being led
Yes.
by Mr.
Lord, I am for defendant number 2 and 2B now by virtue of order dated 7th August 2025, my lord.
Yes.
Being application number GA 22 of 25, it was allowed, and my lord, I am being transposed as a plaintiff now
Yes.
because there was a consistent delay by the other defendants who were creating some sort of
Now
problems
the
in the matter.
question is, are you ready with the report in
Lord,
terms of this
My
order?
lord, I can file the report within 3 to 4 days.
My lord, the report has to be filed jointly by the commissioners. The plaintiff's advocate on record has written letters. None of them has responded to that.
Lord, actually, my lord, as far as my issue is concerned, I was hospitalized, my lord. My lord, I'm being released only 7 days back, so I can.
Lordship will give a time-bound the direction for the joint commissioners to sit down and prepare a report and submit before your lordship.
Advocate representing the joint commissioners and learned advocate for the plaintiff are present. In terms of the order dated 7th August 2025, the report is not yet submitted, and
My lord,
and it is prayed on behalf of the joint commissioner that some time be granted so that the report may be filed on the next date fixed.
My lord, one of the defendants, one of the advocates for one of the defendants, my lord, defendant number 4A, B, and C, my lord, has written a letter replying to the plaintiff's advocate on records letter, my lord, requesting for some time due to a surgery that she has undergone, my lord.
It is submitted by the learned advocate that due to surgery undergone by
My lord, the advocate on record
by the advocate on record appearing for
defendants number 4A, 4B, and 4C. My lord, this is my
4A,
letter.
4B, and 4C. The necessary steps could not be taken.
My
Stop.
lord, if I may humbly say this, my lord, the advocate on record for 4A, 4B, and 4C, she is not one of the joint commissioners, my lord. The commissioners can take a cognizance of the valuer's report and sit down.
Advocate's presence is required, okay. However, in the facts and circumstances, let this matter stands adjourned till
My lord, I am for the defendant number.
Yes. 3/9/2025 for submission of the report without fail.
Deeply obliged, your lordship.
Yes, necessary cooperation to be extended by the learned advocates.
My lord, would the letters be kept on the
Okay,
record?
let the letters submitted by the learned advocate be kept with the record.
Deeply obliged.
Item number 628. On the
You know.
last occasion, you lost. Appoint me as a amicus curiae.
So have you talked to the
I visited number of times to the office of the learned advocate for the profounder. My lord,
Yes.
I have no cost paper as yet, my lord. But lastly, I was compelled to wrote a letter, my lord. But I have no cost paper as yet right now. Very unfortunate. Other than I peruse at least by reading, how should I assist before you lost it? Lordship, kindly direct the learned advocate for the
Directional Well, I am for the plaintiff in respect of testamentary suit number 108 of 1985 converted into testamentary suit number 17 of 2017. Well, so far me is concerned, my lord, we are
this is TS 1 of 2012.
today, my lord, they are this my Joyavati Barik is appearing for
So
TS.
TS 1 of 2012, we are representing whom?
There, I am representing as a defendant.
Okay, opposite party.
Opposite party.
Okay, the other cases.
Other is testamentary suit number 108 of 1985 converted into testamentary suit number 17 of 2017.
108 of
108 of 1985, which has been converted into testamentary suit number 17 of 2017.
17. Okay, in here you are the
But that
petitioner.
particular subject is concerned, I am proceeding with a current will.
Okay, you are the petitioner.
I am the petitioner in respect of this matter.
Okay. So what is the present stage?
Present stage is, my lord, according to me, my lord, my submission.
No, as per the
All-
records, as per your papers.
As per my papers, my lord, all necessary interlocutory proceedings is complete.
Yes.
As of today, there is no question of further interlocutory proceedings. Only the suit to be heard.
Okay. That
Both
means,
the suits.
that means the witness action is to take place.
Witness action to takes place, and so far my suit is concerned, my lord, in my suit submission, I taken the instruction from my junior also that in my suit, my lord, there is no further scope of any evidence because I have completed that.
You have completed the
Yes.
evidence. Here you are the petitioner.
I am the petitioner in my
And-
suit.
And that is the opposite party who is representing
Joyavati Barik.
Joyavati Badik in person.
Yes,
She is the caveator.
he is the
He
caveat.
is the caveator. So only her evidence is to be recorded.
Yes, my lord.
Hard evidence is to be
And
recorded.
not so possibly, my lord, there is part evidence already been done by Joyabati Barik. If I am not wrong.
Lordship, kindly may I permit?
বলুন।
Lordship, উনি ঠিক বললেন না। এখন পেন্ডিং আছে সাবস্টিটিউশন পিটিশন শুনানির জন্য। আমি অর্ডার এনে লর্ডশিপকে দেখিয়ে দিতে পারবো, কিংবা লর্ডশিপ যদি লার্নের রেজিস্ট্রারকে আদেশ করেন সমস্ত পেপার কালেক্ট করে লর্ডশিপের কাছে পাঠিয়ে দিতে, লর্ডশিপ দয়া করে দেখতে পারবেন 11 ফেব্রুয়ারি 2025 এর অর্ডারটা। এখন শুট না, আগে সাবস্টিটিউশন পিটিশন শুনানি হবে, যতক্ষণ না হবে
Well,
ততক্ষণ
may I
শুট
read
হতে
it?
পারে না।
With humble
I-
request, my lord.
আর লর্ডশিপের কাছে
I-
আমার একটা প্রার্থনা, লর্ডশিপ দয়া
Really,
করে
every time coming,
লর্ডশিপ দয়া করে 16 জুলাই 2025 এর অর্ডারটা একটু দয়া করে দেখেন। আমি এর অ্যাপিয়ারেন্সটা কারেকশন প্রার্থনা করছি।
Amen.
16 জুলাই 2025
What corrections, my lord? I do not follow, my lord.
অ্যাপিয়ারেন্স জয়াবতী বারিকের।
Corrections. I know.
Anyway, so the other case, that is this 2002, here the Joyabati Barik is the petitioner.
Well, so far the, yes, my lord. My lord, testamentary suit number 1 of 2012, no?
One of
2012.
Yes, yes, one of 2012.
Yes, ma'am.
One of 2012,
Joyabati Barik is the petition.
Joyabati Barik is the petitioner. Your is the former case. This,
My case is much earlier, 108 of 1985.
so that evidence is over from the
Well, so
petitioner
far
side.
my submission is concerned, my lord.
Petitioner's evidence is over.
My lord.
Okay, now with regard to this item number, this Purnochando Barik, that is Joyabati Barik in person, in this case, what is the position? You are for
So
the
far
defense.
that case is concerned, possibly, my lord, I may be wrong, my lord. Part evidence has already been given by Joyabati Barik.
Okay,
And if not given, my lord, I do not mind, my lord, if she comes and give the evidence, my lord.
so
She can
thereafter your evidence will be taken.
লর্ডশিপ
So far
কাইন্ডলি,
that particular suit is concerned.
লর্ডশিপ কাইন্ডলি,
These are not hard analogously.
ইয়েস অ্যানালগাস,
hard.
ইয়েস
Being hard, evidence is taken, being taken
Yes,
analogously.
yes.
ইয়েস
Analogous. Yes, my lord.
always suppress lordship
I'm not
trying to grab.
suppressing.
Now the question which comes for consideration is this:
That she will give the evidence.
after her evidence,
The matter can be concluded.
the matter can be
Yes, my
concluded.
lord.
Lordship,
Yes, you do one thing.
Yes, my lord.
You just give copies to the learned advocate.
Yes.
Although she is not interested to take any learned advocate, but I have requested him to assist the court as an amicus.
Your lordship is kind enough, my lord.
Yes, so you please give some relevant papers. You collect it from Mr. Chakraborty.
From Mr.
Yes. It's from the advocate on record of Mr. Chakraborty.
Yes, my lord.
Advocate was very much there. And number of
Sir, my advocate on record will assist.
Anyway, please collect it from him instead of asking the Miss Barik.
I will kindly record Purnendu Das will certainly give handover the all.
Yes.
Mr. Kinjal Kumar Bora.
and lordship, I am appearing in person.
আচ্ছা, ঠিক আছে, আপনি কবে সাক্ষী দেবেন? আপনার সাক্ষী
লর্ডশিপ কাইন্ডলি সব সময় সাপ্রেস করে, আমি আফটার 2 weeks টাইম চাইছি, আমি অনারেবল কোর্ট অর্ডার এনে লর্ডশিপকে দেখিয়ে দেবো।
My lord,
just one thing, did she file any examination in chief in the form of affidavit?
possibly, my lord, yes, I will check, my lord.
লর্ডশিপ
She has already also filed an examination of chief. In the sense, my lord, evidence has already been started to be given by Joyabati Barik.
No,
Lordship,
if examination in chief is filed, that because she is appearing in person, okay?
No, my lord,
no,
sorry,
I am
she has not yet filed it, but my lord, I will check it up whether from the witness box any evidence has already been given by Joyabati.
Because you see, because she is appearing in person, only thing is examination in chief in the form of affidavit can be filed and she can be cross-examined.
No,
My lord,
That is only thing which
Your
can be
lordship
done.
can also direct that, my lord.
no লর্ডশিপ, প্রথমে সাপ্রেস করে লর্ডশিপ সাবস্টিটিউশন পিটিশন শুনানি না হলে কিচ্ছু শুনানি হতে পারে
কাকে
না।
সাবস্টিটিউট করব?
Our substitution, nothing is.
কাকে সাবস্টিটিউট করব? কে গত হয়েছেন এখানে?
ওহ লর্ডশিপ,
There was Goto. Lord, I will tell you,
লর্ডশিপ,
lordship.
ওনার ক্লায়েন্ট,
না, আপনি তো প্রথম থেকে আছেন ক্যাভিয়েটার হিসাবে,
ক্লায়েন্ট,
হ্যাঁ?
হ্যাঁ আমি সব অবজেকশন দিয়েছি।
আপনি ক্যাভিয়েটার হিসেবে তো আছেন, একটাতে আপনি পিটিশনার, একটাতে ক্যাভিয়েটার।
হ্যাঁ
এখন কাকে আপনি সাবস্টিটিউট করতে চাইছেন?
আমি চাইছি না, ওনারা পিটিশন করেছেন, সেই পিটিশন পেন্ডিং আছে।
Yes, your petition
I will tell you,
লর্ডশিপ
lordship.
Yes.
কাইন্ডলি, লর্ডশিপ
Lord,
কাইন্ডলি
there were
একটা
two
দুই
GA
একটা
applications.
টাইম প্রার্থনা করছি।
There were
বলতে দিন ওনাকে।
There were two GA applications So far, the matter relating to testamentary suit number 1 of 2012. In that matter, my lord, right? Well, in that matter, one of the person, that is our Nitai Chandra Barik, who was the caveator really, so far their suit is concerned, had died. And thereafter, my lord, substitution had been effected with regard to the other heirs. But amongst the other heirs, one heir, that is Nader Chand Barik, having died, my lord, we prayed for that Nader Chand Barik's name be removed. That has already been removed also. Now, that if that particular part is concerned, my lord, everything is completed now. And, my lord, so far the substitution of the heirs in respect of their proceeding is concerned, that is also today complete because they have filed a GA number 8. And GA number 8 is already allowed.
No,
asking-
no, pending for hearing.
Okay, yes,
Lordship, kindly
yes,
read
Mr. Chakraborty.
the order.
Anyway, I am giving you time, you just bring a compilation, okay, of the necessary orders.
Lordship, kindly GA 720 and GA 824, two petitioner pending for hearing.
ঠিক আছে,
But should I tell
if
me
it
that
is
this thing,
pending-
my lord,
Kindly
GA
please
number
keep
8 is already disposed of.
No, no,
one thing, I am giving you some time. You bring a compilation and a list of dates, okay?
Right.
Let us ascertain the
My lord,
position.
I will certainly.
You give Mr. Boral, yes, Mr. Boral, some of the copies which he requires, so
My
that
lord,
he can
it will
assist the.
require some time. Your lordship will kindly
Yes,
adjourn
I am
this
keeping
matter.
it after 3 weeks or something like that.
4 weeks, my lord.
Okay. Yes, record an order.
Thank you.
Lordship, kindly three matter.
Learned, Mr. Chakraborty, learned counsel for the petitioner in TS 17 of 2017 and caveator in TS 1 of 2012 is present. Joyaboti
So
Barik.
far, 1 of 2012 is concerned, she is the petitioner.
No, I am recording your name as a caveator.
As a
Mr.
caveator in
Chakraborty
that-
as a petitioner in this matter and a caveator in this matter.
Sorry.
MS Joyaboti Barik, who is the petitioner in TS 1 of 2012 and TS 17 of 2000 and petitioner in TS 1 of 2012 and caveator in TS 17 of 2017 is also present. Mr. Kinjal Kumar Boral, who is appointed by the Legal Service Authority.
No, Lord, Kinjal Kumar Boral is my advocate.
Oh, sorry.
Subroto.
Oh, Mr. Subroto Bhattacharya, learned advocate appointed by the High Court Legal Service Committee is present. Mr. Bhattacharya was appointed to render legal assistance to MS Joyaboti Barik. Although MS Joyaboti Barik is pleading her case in person, but to assist this court, Mr. Bhattacharya is requested to be present. Mr. Chakraborty, Mr. Learned Advocate, Mr. Boral is requested to give the relevant documents to Mr. Bhattacharya for necessary assistance to this court. Let this matter,
Well, compilation of these things.
yes, let this matter appear on 17/9/2025.
My lord.
Lordship, kindly, my lord, kindly, that they already matter fixed, kindly after 2 days or before 2 days. Any day, Lordship.
17 অসুবিধা আছে?
হ্যাঁ, ওই মামলা আমার একটা ডেট ফিক্সড
আচ্ছা।
আছে।
ঠিক আছে।
Then, my lord,
19,
Monday on 22nd.
that is on 15.
15, my lord.
15.
May I check? Yes, my lord.
On 15/9/2025, learned advocates, Mr. Learned Counsel, Mr. Chakraborty is requested to come with a compilation and list of dates and the necessary orders which are already passed in this case.
লর্ডশিপের কাছে আমার আরেকটা ছোট্ট প্রার্থনা আছে, যদি দয়া করে 11 ফেব্রুয়ারি 2005 এর অর্ডারটা রানের
এই
রেজিস্টার
সমস্ত অর্ডার নিয়ে আসবেন ওই দিন।
Or if necessary, if she help me, I will certainly allow her to help me. my lord.
আপনি দেখে নেবেন কি কি অর্ডার মানে প্রডিউস করতে হবে, উনি সমস্ত অর্ডার নিয়ে আসবেন ওদিন।
In fact, my lord, she supplied the order copy. I will bring it.
Very
I will bring it. That's it.
yes.
Item number 9.
But item number 9 would appear for the plaintiff, but your lordship had referred this matter to mediation.
Yes.
But and today was, my lord, fixed for filing
Let me
the
see the order.
report. But today was fixed for filing the report by the mediator. But the mediator has held one sitting. The defendant was absent.
Anyway, some time is required.
Yes, my lord, the next date is fixed on 23rd by the mediator.
Okay, I'm keeping it after
After
Puja
3 weeks.
vacation.
Your lordship, please.
Yes, record an order. Learned advocates for the parties are present. Today is fixed for filing report of the learned mediator. As the mediation proceedings is not yet concluded, and the next date fixed is 23rd
23rd of August,
2025. Let this matter appear on 27/10/2025 after vacation.
After
27/10/2025 for filing report by the learned mediator.
Grateful.
Grateful.
Let a copy of this order be served upon the learned mediator.
Grateful.
Item number 12.
My lord. Kindly refer last order of your lordship, 2nd August 2025, connecting orders of coordinate bench. My lord, asking for status of the suit for partition, which is absolutely standing at witness action of plaintiff number 2B, 2D and 2C, who are contending this partition suit in spite of being sons and daughter of original plaintiff late Gopal Chandra Niyogi, who died on May 2021, my lord. Apart from this, my lord, last order of
Just anyway, let me see the report of the registrar. Yes, who is representing the plaintiffs?
I myself am appearing in person.
No, there is another plaintiff, another defendant is also there.
I'm
Yeah.
the defendant 3A.
The suit is pending. Preliminary decree is passed. So what is the latest position? The steps taken by the commissioner?
I'm sorry, I'm
Commissioner
not
did not, we did not see Commissioner of Partition, but we have found his name in order
Yes,
of
record an
August.
order.
My lord, entire suit premises is under threat of trespassers under leadership of plaintiff number 2B, 2D, who are absconding witness action, my lord. So witness action.
Anyway, the registered learned advocate, the plaintiff number, what is your
3A, but these
Plaintiff-
3A, my lord, just
plaintiff number 3A with
Kindly
the
allow me
in
to say, my
person
lord,
is present?
she is coming with a will without probate. So without probate, she cannot enter into a partition suit, my lord.
Let me ascertain the position of the suit,
Yes, my
please.
lord. Yes, my lord.
The report is submitted by the register original side that the suit is still pending. Stop. As the preliminary decree is already passed,
And has been
it is not
Satisfied.
clear as to what steps is already taken by the commissioner with regard to the partition of the suit property. Let this matter appear on
kindly fix a date, fix time, my lord, so that I can explain who are the owners, what is their position, how the partition will take place, how allocation will take place. All these things I have to explain, my lord.
let this matter appear on
Kindly fix time.
3/9/2025. Learned advocates are requested to come with the necessary instructions as
And,
to the present position. Yes, you are representing whom?
plaintiff numbers 2A to 2D, my lord.
So, are you aware at what stage is the present suit? What steps taken by the commissioner?
No, my lord, the documents were missing from the record.
So, come with the necessary instructions and necessary documents. I'm keeping it on 3rd of September.
Lordship,
Kindly
kindly
fix
not
time for
third.
me.
My senior is a little bit busy.
These
Second of September?
Yes, my lord. My lord, kindly fix the time, my lord. I need at least
Let it
30 minutes
appear
to
on
explain.
2/9/2025
Kindly fix
under
time.
the same heading.
My lord, at the same time, my lord, it is most.
It will be taken up. Whatever time is there, it will be taken up.
My lord, police will find out under instruction of your lordship who are the trespassers and outsiders encroaching in position of 4 resident owners. Most of them are ladies and have destructed our position. All these things are to be. This is a root cause of root reason why we are coming to court
Let
beseeching
me
partition, my lord.
dispose of the matter expeditiously so
Yes,
that your
my lord.
problem is solved.
Yes, my lord.
Yes, come with necessary instructions on 2/9/2025 and with the documents.
My lord, just to tell you, my lord, this particular, my lord, each moment of pending status is harmful for us, my lord. Kindly
I'm
consider
trying
this,
to
your
dispose
lordship.
it off expeditiously.
Item number 13.
My lord, 13 I appear for the plaintiff.
No, 13.
I'm appearing for the I am for the
Defendant in
joint
this matter, your
special
lordship.
officers appointed. On 16th of July, has appointed joint special officer to inspect and to inquire the 2 properties. One is at Benares and another is at Cuttack. With respect to property at Benares, we have conducted an inquiry.
Where is this? Just a minute. Okay. So today was fixed for filing the report of the special officer. You are representing?
The joint special officers, the Benares property has been inspected, with respect to Cuttack property, we need some time, to
So Benares property is inspected.
inspected,
You are ready with the report also?
No, we are,
You want to file a comprehensive report?
comprehensive report,
You are representing?
My application is GA number 17. My predecessor had filed GA number 15. It's for substitution and to carry forward GA number 15.
So this order was passed in GA 18.
Yes, sir.
But I appear for the applicant in GA 18.
But this copy of GA 18 be served upon us also because the Lordship's order of 16th of July 2025 records that GA 18 is to be heard along with GA 17 and 15. So GA 18 may be served upon us if the parties want to file an affidavit.
So what is your status in the suit property?
The GA 15 was filed by my predecessor challenging this consent or settlement decree as a part of fraud. During pendency of GA 15, the applicant passes away. GA 17 seeks to come and carry forward that GA 17 because I am saying that I am also entitled to be, and this suit has been, the decree has been obtained collusively between the parties to the suit, contrary to the trust deed. But there is a trust deed. X and Y claim to have settled the dispute. The settlement is contrary to the trust deed. They have identified who's going to be a trustee. They hold the terms of the trust deed.
Yes, record an order.
My lord, only thing is that I would like to join issue over here. My lord, with respect to the trust deed, my lord, I am saying being the applicant in GA 18 that I am the trustee who is entitled to carry on represent the trustees. I am the settler because it follows the law of primogeniture where the eldest member.
With regard to that, I have made observations in my earlier order.
Yes, my lord.
Learned
Yes,
advocates for the parties are present.
4 weeks time maybe.
Yes, learned advocate representing the joint special officer is also present and pressed for time to submit the report. It is submitted by the learned advocate for the joint special officer that Benares property has been inspected, but time be granted to inspect the property at Cuttack. Thus, this matter stands adjourned till 19/9/2025. You are getting almost 8 weeks time. Let the inspection of the properties be concluded and report be filed on the said date. Let GA 17 of 2025 be also listed on the said date along with
17 along with GA 15 and GA 18.
Okay, let GA 17, GA 15,
17 and 18
be listed along with GA 18 of 2025.
I'm grateful.
Lordship's order of July 2025, there was an injunction that was passed. That was for 8 weeks.
Okay, the injunction granted earlier shall continue for a period of 5 weeks or till further orders, whichever is earlier.
Item number 14.
The special officer are granted time for a period till 19/9 to submit. মানে রিপোর্ট উইথ রিগার্ড টু কটক প্রপার্টি বেনারস প্রপার্টি তো হয়ে গেছে কটক প্রপার্টি ইন্সপেকশনটা বাকি আছে প্রথমে তো বেনারস প্রপার্টি তারপরে এটা কটক প্রপার্টি
For the
Yes,
defendant,
call the
my eviction suit, my lord, pursuant to your lordship's direction, your lordship permitted them to discover new documents after 6 years as a
after payment of the cost.
Payment of cost. That has been completed. Now the suit should be heard. It should come up for framing of issues.
And may I file the
Judges brief of documents.
may I file my judge's brief? And that has been served to my
Our
lord.
charges brief have been filed.
And I've already served, my lord.
Yes, record and order. Learned advocates for the parties are present. Discovery and inspection is already complete. Learned advocate for the defendant files judge's brief of documents. Let the same be kept with the record. Let this matter appear under the heading framing of issues on 1/9/2025.
Item number 15.
I beg to appear on behalf of the plaintiffs, not my application.
15, 16 and 17 are nonetheless, my lord. 15, 16, 17 together.
15, my lord, I am for the applicant, my lord. I am led by Mr. Anindo Haldar. Lord, Mr. Haldar is ill, my lord. He is not coming to the court.
15 is your application?
My lord. Substitution application.
Okay.
Lordship, 16 is my application.
16 is your application
And,
for removal of the this thing, administrator.
My lord. And I think, my lord, 17 is also appearing, but 17 has been disposed of. This is an application for striking out the name of the person who had died because rest of them were already on record. This was.
Let me see. GA15 is your application.
My application, I am led by Mr. Anindo Haldar, my lord.
Okay, I'm just making it not today. Come tomorrow.
My lord, kindly make it after 25.
Yes?
He will not be available, my lord. He is ill, my lord. After 25.
Yes, record and order. It is submitted by learned advocate on behalf of Mr. Submitted by the learned advocate that Mr. Anindo Haldar, who is representing the applicant in GA15 of 2024, is ill and could not come. Thus, this matter stands adjourned till 27/8/2025.
27th, my lord.
27/8/2025.
My lord, I'm for the commissioner, my lord.
Yes, give your presence.
Yes, sir.
Let this matter, the other matters, GS16.
GA16 may be heard out, my lord, if my lord wishes.
And GA17 has already been.
GA17 has already been disposed of.
Item number 17. GA17 is of 2025 is already disposed. Let this matter go out of the list. GA16 is your application.
If my lord wishes, my lord can bear out.
Anyway, you come on 25th.
27th,
Sorry, 27th. Item number 16 করে দিন. Let this matter appear on 27/8/2025. Separate. 17টা go out of the list. আর 16টাও তাই 27 তারিখে.
Receivers account, item number 18.
Grateful, my lord.
I'm the administrator in this matter. On the last occasion, Lordship directed me to come with an application seeking discharge. I have filed.
Yes, you are representing?
I am representing the plaintiff, my lord, the executor propounder.
Yes,
My lord,
all along you were not seen.
My lord,
All along there was no appearance from your side.
I've just received instructions, my lord, that
That is all. Your client was not at all alert all these days.
No.
And the administrator had to appear.
I'll give the reason, my lord. My client has been suffering from cancer. She has been detected recently, and that's why, because of the treatment, there was a communication gap also with the advocate on record. But I have received instructions, my lord. From what I understand, my lord, the administrator has been appointed in respect of one property, Rajasthan, in Kanpur, my lord, outside West Bengal. That's just one property. The tenants are there, but they are not paying rents. Now the admin.
Not even there. The building is in bad condition.
The building is in bad condition. Now kindly allows me 2 weeks time to file an affidavit to come up with a solution, Because if today the administrator is discharged, the property will be left for the dogs, my lord. Property will be lost. to
Okay,
estate.
last,
I am in some personal difficulty. Lordship may discharge me and appoint a new administrator.
Kindly gives me
because of
2
some
weeks.
personal difficulty, I am unable to visit the premises and collect rents.
My lord, may I just
so
only
shall I
indicate-
appoint another person as a joint administrator?
Oh, may I just
So that you will not have some difficulty.
Lordship may do, but Lordship may discharge me if.
My lord just kindly grants me 2 weeks time. 2 weeks time, my lord, will come up with a solution, my lord. If possible, my lord, if the property could be sold and the money received and kept in a fixed deposit.
Last occasion, when they were represented by the advocates, they had said that they have no objection to it.
No, I'll just indicate what my apprehension is, my lord.
So what is this GA6? GA6 is
This is my application, my lord, which I had filed long back. It was for repair and renovation of the premises, and I was asking for some funds because the estate did not have enough funds. But my lord, I'm not pressing it since I'm praying for discharge. I'm not pressing.
A9 is for discharge.
GA9 is for discharge. GA6, I'm asking for withdrawal. As
And
not-
probably on the last occasion, I granted you liberty to withdraw some of the amount as your remuneration.
Lordship.
My lord, I want to come up with a solution which will take care of entire thing, my lord. I had proposed to my
But be present on the next day.
Yes,
don't
yes,
avoid.
yes. I will be present, my lord. My lord will, and I'll also file an affidavit. I was hoping, my lord, if the property could be sold, because it's in Kanpur, it's an absolutely dilapidated state, my lord.
Anyway, if she is unable to go,
That's why I want to sell it
some
off.
alternate arrangement. has
That
to
is
be
what
made.
I was wanting to.
Anyway, just wait for 2 more weeks.
I am not opposing her prayer. I am just apprehensive that if today she is discharged and there is no administrator or somebody new is appointed who takes time to visit the property might be lost.
Okay, record an order.
Kindly grants me 2 weeks time, my lord, and I'll come up with something, my lord.
Learned advocate for the plaintiff and learned administrator are present. Learned advocate for the plaintiff prays for 2 weeks time to take necessary instructions in this matter. Let this matter appear on 3/9/2025 under the same heading.
My lord will
3rd of
kindly.
September.
Yes, my lord. My lord will kindly record that none is appearing for the defendant. My learned friend has served the defendants, but they are not appearing.
Lordship, my difficulty is I have served. My clerk went to serve personally. Both of the parties refused. Then I have my clerk sent it by post. But I am unable to take the track records because the last updated track record is of 9th August. They have not updated the portal.
Anyway, if possible, if you know who is appearing for the
My
defendant,
clerk went to serve by hand.
oh,
They
he has refused.
They refused to take it.
Okay, on the next day you give that, you submit that report. Anyway, I've recorded his presence.
Yes, my lord. I'm extremely grateful to my lord.
Item number 19, then 20.
My lord, 19, I appear now with the petition, my lord. This is regarding, my lord, sale of some of the properties.
In respect of the item number 20, the Mr. Sakko Sin is appearing. He is on
Item 19 or 20?
19, my lord, regarding, my lord, sale. My lord, seeking your lordship's leave. This is regarding sale.
This item 20, Mr. Shen is appearing.
He is
Okay,
on
20.
reg in code number 13.
In item 20 also, I appear for one of the Milord receivers appointed by this court, Milord, joint receivers.
Anyway, so
If Mr.
let
Ted is
Mr.
interested, your lordship may kindly keep the item 20 tomorrow.
No, I can make it not today, this item 20.
My lord, instead of, my lord, tomorrow, your lordship kindly, my lord, fix it to Monday. My lord. Tomorrow I have difficulty or Friday.
Okay, item number 20, not this week.
This week.
Yes, Monday.
And 19, your lordship, my lord, has fixed, my lord, other matters on 1st of September. My lord, your
Okay,
lordship,
item number 19, record an order.
Your lordship just may kindly just
20
monitor
to
this,
police,
your lordship may kindly keep the matter in the top, Milord, because as per the last order, the matter was to come within the first 5 matters. But the matter is appearing as item 20. So your lordship may kindly.
Anyway, they are seeking adjournment, let them come.
Yes, yes, Milord, I am agreeable to adjourn.
Okay,
but
item
if some precedence.
item 19, let this matter appear on 1/9/2025.
Some precedence, your lordship.
Anyway, it will be taken up, don't worry.
Great.
20 of this.
Yes, your lordship.
Yes, your lordship, in this matter, I am appearing on behalf of the petitioner,
in respect of GA number 15, the item number 21. But your lordship, in respect of GA number 16, no
Lordship,
copy
I-
served upon us, your lordship.
Your
As
Lordship,
it is
I
arose,
approached the plaintiff in this matter, Your Lordship. GA 15 is my learned friend's application for adding
for addition of parties, your lordship.
parties adding him as
Are
a
you ready
defendant.
with this matter?
That application was served upon us last week, Your Lordship.
No, your lordship. No, your lordship.
GA
2 months
15.
back. 2 months back. 2 months back, your lordship.
My
Yes,
instruction
yes,
is
your
that
lordship.
GA 15.
It is very much apparent from the record.
No, no.
Yes, you are the plaintiff. We have served. We have served.
So are you ready with this J15? Are you ready?
Has not been served. In this regard, your lordship, I can file an affidavit of service, your lordship, which we have served upon them in the month of 16/6/2025, your
Your
lordship.
Lordship, my instruction is that GA 15
G15.
was served upon us last week, Your
That
Lordship.
means your client has served upon you. It's not that your client was not served.
Your Lordship,
Wait,
my
wait, wait.
Your
2
client
months
was
back.
served long time back, but they have served
Exactly, your
upon you.
lordship.
So you require some time.
Yes, Your Lordship. I have
The
been
lordship,
instructed that it was served last week.
it is served upon them personally by us as per the direction of your lordship long back in the month of July, your lordship.
She's seeking some time to
I
file
am
the
praying for
affidavit.
1 week's time, Your Lordship.
Yes, record an
If your lordship, it's my humble prayer before your lordship, if the time is granted, subject to the amount of cost, your lordship.
No, not at this stage. Learned advocate for the applicant in GA 15 of 2025 is present. Learned advocate appearing for the plaintiff prays for time to file the affidavit in opposition to the said application. Let affidavit in opposition be filed by 28/8/2025. Reply, if any, by 3/9/2020.
3/9, lordship.
Let this matter appear on
3/9, your lordship, it will be a bit short time as because my client is out of station, your lordship, for his treatment.
Let it by 8/9/2025.
8/9, lordship.
Let this matter appear on 10/9/2025.
10/9/2025.
So far as GA 16 is concerned, it is an application of a party for being added into GA 15 as a respondent. So that I do not oppose. But so far as GA
Who is the applicant? GA 16?
GA 16 applicant is not present, your lordship.
Let this matter appear on 10/9/2000.
10/9, lordship.
Let this matter 3/9/25. না 3/9/25 না, ওটা 8/9/25 করে দিন।
8/9.
10/9/25 আর এই পরের যেটা আছে item 22, let this matter appear on 10/9/2025.
10, lordship. I'm grateful, dear lordship.
Number 23.
But my application yes, your application for the repair and renewal. Repair.
Yes, for
I
repair.
have to file your opposition.
Lordship, we are filing an appeal against the order dated July.
Question is your affidavit in opposition to this application of Mr. Mitra is ready.
Lordship, no.
You
Because
see, you
we
want
filed the memo
immediate
of appeal.
disposal and you are not ready with this
First
opposition.
July order. The
So long time ago, probably in the month of June, this order was passed.
Lordship, because we filed.
Yes, sometimes back, my lord. I don't remember exactly the date.
Lordship, 1st July 2025.
No, 1st July probably was the extension.
Lordship, and thereafter on.
Earlier, there was in the month of June, it was passed.
No, Lordship, 1st July 2025, may I hand over a copy of that order? Thereafter, the time was extended on the 5th of August 2025, Your Lordship.
So both this application, GA 15 and 16.
Yes,
Yes, record an order. Learned advocates for the parties are present as affidavit in opposition to this application could not be made ready by the learned advocates. Such time is extended till 29,
Lordship, 1 week more, Lordship.
4/9/2025. Reply, if any, by 12/9/2025. Let this matter appear on 15/9/2025 at 3 p.m.
Can it be on 16th instead of 15th?
Okay, 16/9/2025 at 3 p.m.
Lordship, grateful.
Two application.
Yes, next also same order.
Lordship. Yeah, same order, separate order.
Number 24.
Lordship, I appear for the defendant number 2 in this. Lordship, we were to
Appear for defendant number 2, my lord.
Yeah, 12, Your Lordship, may I file my affidavit, Your Lordship, on the last occasion? Your Lordship directed us to file an affidavit.
Lordship, I am for the
Let me
defendant
see
number
the last
1.
order.
Lordship, I was to file my exception to the special officer's report, Your Lordship. However, due to a technical problem in the affirmation, Your Lordship, it'll have to be reaffirmed. So kindly give me 1 week's time, Your Lordship, to do the same.
I am filing a supplementary affidavit because Your Lordship had directed the bank to furnish certain information
We'll take.
with better clarity. So that on the previous day we had filed the affidavit, but thereafter we received certain other documents from the bank that I'm bringing on record
Just to
by way of the
take
supplementary.
time to file exception.
So you are filing supplementary affidavit today.
Yes. In
My lord,
terms
copies have not been served, my lord.
circulating a copy.
If you can kindly serve a copy to us.
Hidden in the supplement.
Lordship, I also seek leave to file my wakalatnama in the main suit, Your Lordship.
So representing defendant number
1. Lordship, inadvertently, Your Lordship, it's a change brief, therefore it wasn't done, Your Lordship. So kindly give me leave. Do the same. RAS double H MI.
Yes, today you are filing the supplementary affidavit. Copies have been served.
I have served copies.
Just today.
Yes, today.
Double E.
We have filed, Your Lordship, the affidavit in opposition for the plaintiffs, Your Lordship, in GA12.
So GA12 they have filed, my lord. GA13 they have not filed anything. And for GA12 we have been served. We will file our rejoinder to their affidavit what they have filed.
GA12 is whose application? Your application.
Yes, my lord, my application. GA12, 13 and 14 all are my applications.
He's the defendant number 2, Your Lordship.
Yes, record an order. Learned advocates for the parties are present. Earlier, in terms of earlier order dated 28 July 2025, liberty was granted to the defendant number 1 to take exception to the report of the special officer. Stop. However, report of the special officer, however, such exception is not taken till today and time is sought for. In the interest of justice, the time is granted to take exception to the said report.
I'm grateful.
My lord, they have filed their reply. The learned joint receivers have filed their reply. Plaintiff have filed their reply to GA12, my lord. I'll be filing my rejoinder to the same. We have been served upon it.
The supplementary affidavit, which is filed by the joint receivers, be kept with the record. Copies be served.
The copies have been served.
Copies have already been served. Affidavits with regard to the said supplementary affidavit may be filed as affidavit in opposition to GA12 of 2022. So only GA12 we have filed affidavit in opposition.
14, Your Lordship, the pleadings have been complete.
Okay. GA12 of 2022 is filed by the parties. Let the reply be filed on or before 3/9/2025.
My lord.
Let this matter appear on 3/9/2025.
Not 3, can it be, my lord, 5th, not 3, my lord?
Fifth is a holiday probably,
Yes, yes, my lord.
or second? You want
Second, no, my lord, after 5th, any day, my lord.
Okay, let this matter appear on 8/9/2025.
Lordship, also the leave to file wakalatnama to the defendant number 1 because it's a change
Number 1 is granted leave to file the wakalatnama
in the main suit.
in the main suit. In the facts and circumstances, the special officer be paid a further remuneration of 100 GMs.
Grateful, dear Lordship.
Grateful, Lords.
Item number 25. This is my application.
But this that Order 7 Rule 11 matter, my lord. With regard to that lease expiring by efflux of time, the suit filed beyond 12 years. But I had placed 3-4 judgments on the point that Article 67 would apply, which says that, my lord, that time to file a suit is 12 years. Read with Section 27 of the Limitation Act, which says that the right to property extinguishes beyond the period prescribed.
Yeah, probably you have concluded on the.
Just 2-3 judgments more, and I shall conclude, my lord. Otherwise, on fact and everything else, I have concluded. Just 2-3 judgments more, my lord. And I shall conclude.
Yeah, record to the.
এইটা দেখানো হয়েছিল 15 সেকশনটা দেখানো হয়েছে একবার দেখি দেখানো হয়েছিল কি এইটা দেখানো হয়েছিল কিনা মনে হয় কোনটা দেখাচ্ছি ওইটা my lord, one judgment, my lord, on the point that it cannot be a continuing cause of action, my lord, for an eviction suit, because the day when the lease expires by efflux of time, that is the date from which the cause of action arises. It's not a
expired by efflux of time. So was any special or any other notice issued to vacate?
No, nothing issued.
Simpliciter after efflux of time, the suit was instituted.
Yes.
It's
Beyond
not a
12
case of
years.
termination of lease?
No.
Or notice
Not
to,
a case of notice to quit.
to quit.
So suit filed beyond 12 years or from the date of expiry. This is the fact, my lord. Now, my lord, in the affidavit in opposition, the plaintiff has sought to make out a defense that, my lord, this is a continuing cause of action, so it is not barred by limitation. So, my lord, to try and buttress my point that in this kind of matters, Section 23 of the Limitation Act cannot be pressed into operation. Just 2 judgments for that one. If your lordship kindly permits me to place, my lord, All India Reporter, 1942 Patna 188. May I place it, my lord?
Yes.
This is on the proposition that even if wrong is continuing, the right expires after the expiry of the period of limitation. Now, kindly sees, my lord, kindly sees the first paragraph that there is a second appeal by the defendants against the decision of the learned district judge of Darbhanga, reversing a decision of the Munsep of Madhubani and decreeing the plaintiff suit without costs. So, my lord, the decree was passed, my lord, in the appeal. So, my lord, the defendants have preferred the second appeal. So, the suit for eviction, the suit was decreed in favor of the plaintiff. Now, your lordship would kindly have a look at paragraph 9. And I shall be placing reliance on paragraphs, my lord, 9 and 10. May I place it, my lord? This view of the learned judge upon the question of limitation, but I really should start from paragraph 8 because the question of continuing cause of action was there. Paragraph 8. He, however, was of the opinion that no question of limitation arose at all because the construction of the houses by the defendants first party amounted to continuing wrong, giving rise continuously to fresh causes of action under Section 23 of the Limitation Act. In this view of the case, he decreed the suit for the entire disputed land. He allowed no cost to the plaintiff, however, because in his opinion, the suit was not a bona fide one. Though the settlement has been made as far back as 1915, the villagers had not found it necessary to take any action about it for 23 years. And moreover, he noticed that two of the plaintiffs had actually signed the proclamation made in the year 1914 for the settlement of this land by auction issued by the circle manager. This view of the learned judge upon the question of limitation was quite wrong. The question of limitation in suits of this kind has been fully considered by this court in Vibhuti Narayan Singh. In that case, it is laid down that there is nothing in Section 23 of the Limitation Act upon which a distinction can be made between the case of encroachment upon private land and upon public land, and if in the one case of a precisely similar act committed upon public land. Whether the wrong is continuing or not must depend upon the nature of the wrong and not upon the nature of the land over which it is committed. A distinction was further made. A distinction must further be made between the continuance of a legal injury and the continuance of its injurious effects. And there is no perpetual right of suit under Section 23. My lord, kindly marks this. My lord. There is no perpetual right of suit under Section 23, whether a wrong be continued or not, when the trespass itself gives rights to extinguishing any right of suit. When the wrong amounts to dispossession of the plaintiff, then, even although it may be a continuing wrong, the plaintiff cannot recover possession after 12 years, because under Section 28 of the Limitation Act, he himself has got no right left which he can enforce. 10. The real question in a case like this is not whether the wrong is continuing or not, but whether the wrong amounts to a complete ouster of the plaintiff, that is, to his dispossession. Where it is a case of dispossession and the suit for recovery of possession by ejectment of the defendant, then Article 142 of Limitation Act provides a period of 12 years limitation from the date of plaintiff's ouster. Beginning with that article, Section 28 of the Limitation Act, it is clear that the plaintiff can have no right of suit after the expiry of 12 years from his dispossession. For Section 28 provides that at the determination of the period limited in the Act to any person for instituting a suit for possession of any property, his right to such a property shall be extinguished. It is clear that once it must be held that the plaintiff's right is extinguished, it is quite irrelevant whether the wrong is technically continuing or not, so far as the question of recovery of possession of that property is concerned. The plaintiff cannot recover it because he no longer has any right to that property. Not my exact point. So, my lord, the right to recover has extinguished on expiry of 12 years from the efflux of time, as per Article 67, read with Section 28. Efflux of time, plaint case 94, suit filed beyond 15 years. Now, my lord, one other judgment for the proposition. My lord, I am trying to buttress this point of continuing cause of action from another angle also. My lord, may I place, my lord, 2015, Volume 3, Maharashtra Law Journal, page 459. Your Lordship would kindly see, this is on Article 67 of the Limitation Act and Section 106. Your Lordship would kindly have a look at page 461 of the report, towards the middle of the page. The unnumbered paragraph of paragraph 6, where the points of the questions of law has been framed. It is also a second appeal. Kindly sees this. On hearing the learned counsel, has your Lordship got it, my lord?
Yes.
On hearing the learned counsel, the following substantial questions of law arise in the second appeal. Kindly sees the first one, whether it is necessary to issue notice under Section 106 of the said Act to a tenant at sufferance. Then 2, whether the suit filed within limitation as prescribed by Article 67 of the Limitation Act 1963. Hence, admit on the substantial questions of law heard finally with the consent of the learned counsel for the parties. Then kindly see paragraph 7. The factual aspects of the matter are not in dispute. The lease that was granted for a period of 50 years came to an end by efflux of time on 9/4/1988. The defendants had paid rent up to 1983-84, after which no rent was paid to the plaintiffs. On 23rd December 1992, the plaintiffs had issued a notice to the defendants terminating the lease and has demanded possession of the suit property. Said notice was replied on such and such. Thereafter, on 27 February 2002, another notice terminating the lease was issued, and on 11 July 2003, present suit for possession came to be filed. Kindly sees the next page, page 462. Under the unnumbered paragraph which starts from, it is therefore clear. May I place that? It is therefore clear that the status of the appellants was that of a tenant at sufferance. The legal position is well settled that where the lease is for a definite term and it expires by efflux of time by virtue of provision of section 111A of the said act, there is no necessity of issuing notice under section 106 of the said act. Reference in that regard can be made from decision in Shanti Devi relied upon by the defendant. It is therefore clear that issuance of a notice by the plaintiffs on such and such is of no legal consequence, inasmuch as the lease in question came to be determined by efflux of time on 10/4/1988. Accordingly, the first substantial question is answered by holding that there was no necessity of issuing any notice under section 106 of the said act to the defendants. May I pause here for a moment with my lord's kind indulgence? But why I am placing this portion of this? Because if it is the law that after the expiry by efflux of time, the right continues, it's a continuing cause of action, then a notice would have been held to be mandatory. But your lordship knows it is all along the law that in case of expiry by efflux of time, no notice to quit is required.
No, in this case, it is an admitted position that no notice to quit was given.
Yes.
This is an admitted
Yes,
position.
but I am drawing analogy of this judgment in a different sense to tackle the point of continuing cause of action. Now, I am placing reliance on this paragraph 8 for the proposition that, my lord, had it been the law that a right continued after expiry of time or expiry of lease, it's a continuing cause of action, then to end that, a notice would have been required. That would have been the law. Because that is continuing. That has to be determined by 106 notice. That is not the law which because that is not the law which supports my case that these type of cases cannot be said to be a continuing cause of action under section 23 of the Limitation Act. Now kindly takes a look at paragraph 9. As regards the period of limitation under Article 67 of the Limitation Act 1963, suit for possession is required to be filed within period of 12 years when the tenancy is determined. As observed herein above, the tenancy came to be determined by efflux of time on 9/4/1988. It was therefore necessary to have file the suit for possession within the period of 12 years from the date. The suit as filed on such and such was therefore barred by limitation. Both the courts have proceeded to adjudicate the aspect of limitation by taking into consideration the notice dated such and such issued by the plaintiffs. As observed herein above, there is no legal requirement of issuing any notice under section 106 of the Act for determining the tenancy. Hence, both the courts misdirected themselves while considering the issue of limitation. Then kindly turns to, my lord, the last page of the judgment, page 463. My lord, the first line, the right to possession, has your lordship got it? My lord, the right to possession accrued immediately after the lease was determined by efflux of time, and hence it was necessary to have filed the suit for possession within a period of 12 years from the said date. It is therefore clear that the suit as filed was barred by limitation. The second substantial question of law answered accordingly, and the suit was finally held to be barred by limitation in the second appeal. Similar, not only it satisfies my point in my humble understanding, subject to my lord testing it, of course, under Article 67 and the period of 12 years, it also, my lord, addresses the issue of continuing cause of action in a different way. where the court holds that no 106 notice is required. There's no question of that notice. And that notice cannot give a fresh right, fresh period of limitation. Now, only one other judgment, and I shall conclude. Bolo. My lord will kindly pardon my impertinence, my lord. Only one judgment, my lord. I am not fully sure whether I had placed it. 2015 for Calcutta High Court notes, page 75, Division Bench Judgment of Justice Matre and no, then I.
Yes, you are placed.
Yes, I have.
Anyway, after all, with your written notes, you give a compilation.
Well, those are my submissions. So, just to buttress, just to sum up, my lord, suit file, a plaint case, expiry by effects of time in 1994.
So it is governed by Article 67.
Hello.
So lease, expiry of lease by efflux of time.
Governed by Article
Article
67. Read with Section 27 that the right to property stands extinguished after expiry of the period of limitation. So, my lord, they cannot maintain this suit. And it cannot be a continuing cause of action because for cases of this nature, Section 23 cannot be pressed into operation. For that, I have placed these two judgments. Those are my submissions.
Yes, Mr. Dutt.
My lord, your lordship is, my lord, hearing an application under Order 7, Rule 11.
Yes.
So, my lord, A, the suit has to be barred by law. B is that there is no question of evidence required. There is no question of hearing required.
On the face of the plaint itself.
Absolutely. The plaint, and very importantly, the entirety of the plaint has to go.
Yes, yes, yes.
Now, my lord, kindly come. Your lordship has heard my learned friend. My learned friend's submission is one and only one. That so far as the decree for eviction that has been claimed against me, my lord, is barred by limitation. Now, my lord, he doesn't dispute, or he cannot, my lord, kindly come to page 24. Your lordship has the reliefs?
Yes.
My first relief is.
May I have my lord's kind leave, my lord? My junior is. May I?
Yes, yes.
The first relief that my learned friend has claimed, that I have claimed, is a decree for declaration that the plaintiffs are the owners of premises number 42A, Shakespeare Colony, Kolkata 70.
Yes.
So, my lord, this relief, my learned friend is not saying that this relief which I have claimed is also barred by limitation. He is saying decree for eviction of khas possession and khas possession of the suit property more fully and particularly mentioned and described in Schedule A hereunder written, decree for mean profits, decree for further mean profits. These prayers, decree for eviction and for wrongful possession, these prayers are barred by limitation.
That is B, C and D.
Yes. Now, my lord, that strikes at the very first principle of Order 7, Rule 11, that a plaint cannot be dismissed in part. Because my learned friend throughout, my lord, has not argued before your lordship that the entirety of the reliefs claimed in the suit is barred by law. He is only argued on the question of limitation and vis-a-vis the prayers for eviction. Now, my lord, even if for argument's sake, my lord, I take it what he is saying is correct, which is not, but that I'll address. I want a very basic principle that your lordship is deciding an Order 7, Rule 11 where the plaint contains 4 reliefs. Defendant is coming and saying that 3 of the reliefs can't be granted, but he is not challenging the 4th relief. Now, my lord, how would your lordships, in my respectful submission, say that the plaint reliefs claimed in the plaint are barred by law? So, my lord, on the very first principle of Order 7, Rule 11, my lord, this application should be dismissed. Authorities, my lord, I'll cite Supreme Court galore, that the plaint cannot.
Can you maintain a suit for declaration only without praying for the other reliefs under the Specific Relief Act?
If, my lord,
that is another
that
question.
is another aspect, my lord.
Only this much.
Very well. My lord, let's take it, my lord. I have only filed a suit for declaration
Yes,
and
yes.
no consequential.
Under the Specific Relief Act, you have filed a suit for declaration.
My lord, your lordship knows, my lord, 34, my lord, is not a close-ended section. That also the Supreme Court has had. Suppose, my lord, I am in possession of a property and somebody comes to dispossess me. If I have been dispossessed, then I need subsequent prayers. If I am in possession of the property, somebody is questioning my title, the declaration is good enough because I am in possession. Nobody has disturbed it. So, my lord, it is not an universal case that a 34 declaratory relief always has to be. All it says is, my lord, 34, all it says is that if you are seeking a declaration and that declaration decree which is passed cannot be enforced because you have not asked for consequential reliefs, then your declaration is bad.
No, there is another thing that Limitation Act does not forfeit the right, but it only bars the remedy.
I would have come to that second.
That is also another.
That I would have come to my second thing. I want the basic principles first. Well, I could have stopped here by saying that the plaint in its entirety cannot be rejected, and that is an admitted fact. All points to be kept open and the suit to be tried. So, my lord, this is my first point. Now, my lord, my learned friend, the judgment, please. কপি দিতে হবে কিন্তু I'm handing it over right now and I'll make a compilation. দিচ্ছি সাইটেশনটা হচ্ছে 2025 Volume 4 Supreme Court Cases, page 38. Sorry. Will it kindly come to paragraph 4. The facts giving rise to this appeal may be summarized as under respondent number 1, Prabha Jain instituted civil suit such and such, praying for the following reliefs. It be declared that the disputed sale deed and the mortgage deed described in paragraph C above are a nullity, and it be declared that defendant number 4 and 5 have no right to sell the disputed plot to the defendant number 3, and possession taken by the defendant number 2 is against the law, and a grant of loan by the defendant number 1 on the security of the plot is against the law. That the possession of the plot land shown is slanted red lines in the plan attached to the suit may be given to the plaintiff after demolishing construction. Plaintiff may be awarded damages, mean profits. It is the case of the plaintiff that the suit land was purchased by her father-in-law, and after his death on so and so, the same was inherited in equal shares by her late husband Mahendra Kumar Jain's husband, elder brother Sumit Kumar Jain, and mother-in-law. After the death of Mahendra Kumar, his 1/3 share was inherited by the plaintiff. However, Sumit Kumar Jain, without any partition amongst heirs, divided the land into several plots and sold them off illegally to different persons. One such plot was sold to the defendant number 3 with a registered deed of 2010, who in turn mortgaged the same with Central Bank of India for the purpose of obtaining a loan. This is not the fact. It seems that the person who obtained loan defaulted and that is how the bank decided to proceed further in accordance with the provisions of the Securitization and Reconstruction of Financial Assets 2002. So the bank took steps on the surface. It is the case of the plaintiff that the sale deed as well as the mortgage could be said to be a nullity. She claimed possession of the land in the suit. It appears that the respondent appellant bank herein preferred an application under Order 7, Rule 11 and plead that the plaint be rejected as the civil court has no jurisdiction to try the same in view of Section 17 of the SARFAESI Act. The trial court rejected the plaint. The original plaintiff carried the matter before the High Court. The High Court allowed the first appeal, holding paragraphs 9 and 10 respectively. From this, then Millard, these points, High Court's judgment is there. In such circumstances, the High Court reversed paragraph 9. In such circumstances referred to above, the appellant bank is here before this court with the present appeal. We have heard Mr. Such and Such, learned advocate, appellant and Mr. Such and Such for the counsel. The only argument canvassed before us on behalf of the bank is that
This paragraph?
Paragraph 9, Millard. I'm sorry. I skipped the High Court finding because it reversed.
Yes, only an argument.
Is that in view of Section 34 of the SARFAESI Act, the civil court has no jurisdiction to try the suit. Having regard to the importance of the issue raised before us, we propose to consider in detail. Then, Millard, the list of dates. So this was the issue. 34 was the issue. Niley, Millard, kindly come. After discussing the various provisions of the SARFAESI Act, kindly, Millard, now come straight to paragraph 23. 23.
Yes.
Millard, it is at page 55 of that. Even if we could have persuaded to take the view that the third relief is barred under 17(3) of the SARFAESI Act, the third relief, still the plaint must survive because there cannot be partial rejection of the plaint under Order 7, Rule 11 CPC. Hence, even if one relief survives, the plaint cannot be rejected under Order 7, Rule 11. In the case on hand, the first and the second reliefs as prayed for are clearly not barred under Section 34 of the SARFAESI Act and within the civil court's jurisdiction. Hence, the plaint cannot be rejected under Order 7, Rule 11. If the civil court is of the view that one relief, say relief A, is not barred by law, but is of the view that relief B is barred by law, the civil court must not make any observations to the effect that the relief B is barred by law and must leave the issue undecided in an Order 7, Rule 11 application. This is because if the civil court cannot reject a plaint partially, then the same logic is it ought not to make any adverse observation against relief B. So, Millard, that squarely answers the maintainability of this application. I am arguing, Millard, I am not conceding to the fact that the claim is barred by limitation. But, Millard, what I am trying to say that is it necessary for me to, Millard, take the court's time to argue this? Because my learned friend's case is now come to the Order 7, Rule 11 application. Kindly, Millard, come to paragraph 10, 11, 12, and 13. These are his pleadings. The plaintiffs, I'm sorry, Millard, may I start? The plaintiffs in CS 217, এটা তো 217 নয়, তো আগে সুটটা, no. Millard, Kindly see paragraph 10. That being so,
9.
para 9 he starts. I'll go into that in my second limb of my argument. The plaintiff in CS 217 of 2005, this is not this suit, this is a previous suit,
Yes.
had already sought for a decree of delivery up and cancellation of the deed of lease dated 1st November 1994 and the deed of trust dated 2nd January 1993 and had claimed a contrary title to the plaintiff in CS 99 of 2009, which is this suit. That being so, a claim for declaration ought to have been filed. Ought to have been filed within a period of 3 years when the right to sue first accrued. The claim of eviction of the plaintiff in this suit is consequential upon the claim for declaration. Inasmuch as the claim for declaration is expressly barred by limitation, the other reliefs claimed in the suit is also barred.
So he is hitting on that
He is hit-
declaration. So you have to justify that this suit for declaration is maintainable.
Willard, that suit for declaration is not this suit. That suit which he is referring to, Millard, CS 217 of 2000.
Yes, yes. Earlier suit.
Earlier suit, which is still pending. It's filed by them. And Millard, when I place the plaint, your lordship will find that
So this is the suit of the defendants.
yes,
Okay.
Millard, it has a long history. When I'll come to the facts, Millard, your lordship itself will find that it is a question to be tested in evidence. But be that as it may, thus the plaint filed in the suit is barred by law under Order 7, Rule 11D, and the plaint is liable to be rejected. In the alternative, the suit is dismissed. That apart, the present suit is also barred under Order 7 of the Court of, inasmuch as the plaintiff being the defendant is C17 of 2005, has not filed any counterclaim in C1217 of 2000. Has my learned friend argued any of this before your lordship? Save and except take that last line of my plaint to say that, look, he's filed a suit under 12 years. The case before in the Order 7, Rule 11 involves facts of
Now,
three
the
suits.
other question you see, whether they have filed other suit or not, that cannot be decided in Order 7 Rule 11.
But that is part of the plaint.
Okay. But it cannot be decided in this Order 7
So
Rule
that-
11
So
application.
if that is part of the plaint,
Yes.
that is why the court says, Millard, that if you cannot decide it on an Order 7, Rule 11, you say that this is not a case, fit case to be rejected or thrown out at the threshold. What is Order 7, Rule 11, Millard? Order 7, Rule 11 is that this suit should not proceed to trial at all. Because if it ultimately goes to trial, it cannot be any other thing but get dismissed. It has to be that clear a case. But even if there is a minimum right or a minimum scope of evidence or a minimum scope of trial, Millard, then Order 7, Rule 11 is not the process. Now, Millard,
So they have taken the plea that your suit for declaration, that is the claim for declaration, is not maintainable. That they have taken in this application.
very well, they have taken it.
Yes, yes.
Now, Millard, how does this claim arise? Your lordship has not been shown the plaint in its entirety. Permit me to place some portions of the plaint. Millard, kindly come straight to paragraph page 10. Home Trust is Millard the plaintiff. These are the plaintiffs. And Calcutta International Club is defendant number 1 and Shumit Law is the defendant number 2. Now, Millard, your lordship will kindly notice when I place the plaint how the cause of action are against the two defendants. The plaintiff state that the instant suit is for eviction and khas possession being plot number such and such, together with two brick built property is described. The predecessor in interest of the defendant number 1 and or other defendant and members are incorporated persons in unlawful possession of the suit premises since 25th February 1994 till the date of institution of the suit. The plaintiff number 1 is a registered public charitable trust. The plaintiff numbers 2, 3 and 4 as its present trustees. The plaintiff number 1 is the land stroke owner of the suit premises, meaning 2nd January premises since 2nd January 1993 and the facts hereunder. At all material times, Mihir Kumar Law, since deceased, was the absolute owner of the suit property. On 24 February 1973, Mihir Law, during his lifetime, executed and registered a deed of lease in favor of some of the members of the defendant number 1 in respect of the suit property for a period of 21 years expiring on 24th of February 1994, with an option to the defendant number 1 to renew the said lease for the further 21 years on same terms and conditions, except the rent which has been agreed to be decided and adjudicated upon as per the provisions contained in the lease of deed. The lease of deed is 73 to 94 and 94 another 20 years depending on the lease. During the subsistence of the deed of lease of 20th February 1973, Mihir Law, during his lifetime, on or about 2nd January 1993, executed and registered a deed of trust whereby the said Mihir Law formed a public charitable trust comprising of premises number 42A Shakespeare Sharoni, which is the suit property, being the trust property, and inter alia appointed himself as the sole trustee for the purpose and object as mentioned in the deed of trust, a copy whereof is marked B. The said deed of trust was registered under the Indian Registration Act, significantly suit number 605 of 1991, Anandilal Poddar and Sons versus Mihir Law. While filing terms of settlement on 13 September 2004, the Honorable High Court at Calcutta observed that the deed of trust as registered in the office of the Register of Assurance at Bombay is a valid one, and inter alia ratified the said registration on the basis whereof the Register of Assurance Bombay completed the said deed of trust. So the validity of the deed of trust, my lord, was established in another proceeding, which is before Anandilal Poddar and others versus Mihir Kumar Law. Then I ratified the by virtue of the provisions as contained in the said deed of trust, the individual marketable title of Mihir Kumar Law over and in respect of the suit property vested on the trustees of the said trust estate, and the trustee have not yet divested from such ownership. The said trust was created by Mihir Law, was and or is a public charitable trust guided by the provisions of the Transfer of Property Act. Then, my lord, your lordship can skip the rest of the portion. It is about the trust, which your lordship need not be bothered. Then, paragraph 6. On 24th February 1994, said 21 periods under the lease dated 1973 expired by efflux of time, when Mihir Law was acting as the sole trustee of the said trust under the name and style of the plaintiff number 1. The said Mihir Law did not renew the said lease or execute a new lease in favor of the defendant number 1 upon the expiry of the said stipulated period of lease or even thereafter during his lifetime. After expiry of the said period of lease on 19th July 1997, 1997, the said Mihir Law resigned from the post of sole trustee of the plaintiff number 1, and thereafter with effect from 20th July 1997, Bairu Ratan Pachisia and Dilip Chand Kankaria acted as joint trustees of the trust, who were appointed as trustees of the said trust on 2nd February 94 by virtue of the provisions as contained in the deed of trust. Subsequently, in 2002, plaintiff number 3 was appointed honorable. Subsequently, Dilip Chand Kankaria resigned. Upon his resignation, plaintiff number 4 was appointed one of the trustees. Thereafter, Bairu Ratan Pachasia resigned, and upon his resignation, the plaintiff number 2 appointed trustee. Thus, the right, title, and interest of the suit property vested on the plaintiff numbers 2, 3, and 4 as trustees of the plaintiff number 1. by virtue of the provisions as contained in the deed of trust, and thus the landlords. By virtue of the provisions as contained in the deed of lease dated 20th February 73, and by necessary implication thereof, the plaintiffs, being the owner of the suit property, stepped into the shoes of Mihir Kumar Law. In or about 2007, Mihir Law died, and is a matter of record that until his death, the said Mihir Law, being the author of the trust, never terminated or extinguished the trust created by him, nor took any step to take the trust illegal or contrary to law during his lifetime. Thus, till the death of Mihir Law, and even thereafter, till the date of institution of the suit, the plaintiff number 1 was and or is still subsisting as a valid lawful trust estate. The defendant number 2 is a class 1 heir and legal representative of Mihir Law. Defendant number 2 is the only son of the said deceased. Upon the death of Mihir Law, the said defendant number 2 is denying and or is interested to deny the plaintiffs as the owner of the suit property. So, there comes the declaration vis-a-vis me and the defendant number 2. Because he is disowning the fact that his father had created a trust. This is the declaration.
Disputed by defendant number 2.
2. So that's an issue between me and the defendant number 2 in the suit. The defendant number 2 also purported to file a writ application in the no High Court at Calcutta, raising objection to the order of mutation of the plaintiff number 1 as the owner of the suit property on several untenable grounds, and thereby disputed the right, title and interest of the plaintiff over and in respect of the suit property as owner thereof. The denial is such which cannot be compensated.
So 2007, he is disputing your rights.
Rights.
And the creation of the trust.
Yes.
And filing the writ application.
Yes. And that declaration is not my learned friend's concern.
So this application is taken out by the defendant number 1. Not by the 2.
Milord, may I? Therefore entitled to claim and is claiming a decree for declaration. The plaintiffs are therefore entitled to claim and claiming a decree for declaration that the plaintiffs are owner of premises number 42 as Exshire Parani, the suit property. This is where, my lord, my prayer A is. Now, okay, order 711 to 5. Now, so far as this paragraph 7 is concerned, Milord, it's a very longish paragraph. Para 7, Milord.
Yes.
Which
you have
ends
submitted.
with the declaration.
Yes.
Milord, A, can the defendant number 1 have a say in respect of this relief?
Defendant number 1 is not disputing with regard to declaration. It is by the defendant. Defendant number 2.
Defendant number 2 is not coming with
challenging your right to file this suit. Defendant number 1 has challenged your right to file the eviction, as well as this declaration also.
So, my lord, vis-a-vis that prayer of declaration, I have shown, your lordship just now asked me that no, they are also challenging your declaratory relief.
Yes, in the order 7 rule 11.
Now, my lord, if this is my declaratory relief vis-a-vis the defendant number 2,
that means after 2007 you are aggrieved by this declaratory relief.
And further
from this writ application, you are aggrieved that they are disputing.
My contention is this. I come back to my first point and the start point which I am addressing. So far as this decree for declaration is concerned, can the defendant number 1 say that this decree which has been claimed against the defendant number 2 by the plaintiff is bad? And that would be decided on an application under order 7 rule 11 filed by the defendant number 1. So, my lord, if the defendant number 1, like in that bank suit, the bank may have a favorable order because portion of the plaint, reliefs claimed against the bank, was barred, but the entire suit cannot be barred. So that's the reason why I stopped here to show Miller that this case falls exactly where this judgment of Supreme Court is. 4 reliefs claimed.
That means so far the defendant number 2 is concerned, you are entitled to come with this.
Yes, this is
declaratory
part of the
relief.
plaint.
And so this dispute arose as per your plaint, that is after filing of the writ
Your
application.
lordship will have to take the plaint as correct.
Yes.
Every bit of it is correct. Now, as of now, your lordship will have to take that I am entitled to a declaration. Unless the defendant number 2 comes and says that no, defendant number 2 has not come and filed an order 7 rule 11 before your lordship. So, my lord, coming back to that first judgment which I cited, the bank was only interested in only one relief. So far as the other reliefs A, B, C are concerned, and the Supreme Court says that if you cannot touch all the reliefs, then don't say anything in respect of that relief.
Anyway, so paragraph 7 deals with that dispute.
So, Millard, anyway, Millard, let I now proceed. And I'll show Millard it's not even barred by limitation. In view of the aforesaid, the plaintiffs are the owners of the suit property and are entitled to recover peaceful khas possession thereof. By an order dated 10th February 2007, the Kolkata duly mutated the name of the plaintiff number 1 as owner of the suit property, the plaintiff. It is a matter of record that after incorporation of the trust in the name of the plaintiff number 1 and until expiry of the said deed of lease, the defendant number 1 and of the defendants made payment of the the monthly rental to the trustees, namely Mihir Kumar Law. So they went on paying rent till Mihir Kumar Law died in 2007. So rent paid till 2007. If they pay rent till 2007, they cannot rely on judgments that I was in hostile possession for 12 years because he is paying rent in lieu of occupation.
This is 2009 suit. Yes.
Make payment monthly rent to the trustees, namely Mihir Kumar Law. In view of the aforesaid, the plaintiff state that the defendant number 1 and defendant members have all material ties accepted and admitted the plaintiff number 1 as their lesser landlady by their act and conduct. Then, it is a matter of record that on 25th February 1994, it is a matter of record that on 25th February 94, the defendant number 1 failed and neglected either to tender or to make payment any amount as and by way of rent of the suit premises, being the plaintiff number 1, till the date of institution of the suit or to the said Miller during his lifetime. Neither Miller nor the plaintiff ever accepted any sum towards payment of rent of the suit premises for the defendants after 24th February 9 till the date. Thus, the said deed of lease after its expiry was not held over. The said registered deed of lease of 2470 contained the following terms. I will not trouble your lordship with this. Kindly, my lord, come straight to paragraph 12. This is where, my lord, your lordship needs evidence. On 25th February 94, after expiry of that lease, the registered lease executed by Mihir Law in favor of the defendant members duly expired by efflux of time. The defendants, in spite of having the knowledge with regard to the vesting of title of the property in question in favor of the plaintiff number 1, did not seek for renewal of the said lease or ever requested the plaintiffs to grant any fresh lease in respect of the suit property till the date of institution of the suit. During the lifetime of Mihir Law, the said lease was neither renewed nor any fresh lease was ever granted by Mihir Law in favor of the defendant after its expiry, although the defendants on or about 17th May 1994, kindly will not mark this, purported to file a suit being titled suit number 1345 of 1994, International Club versus Mihir Kumar Law, against the said Mihir Kumar Law before the City Civil Court at Calcutta, wherein the defendant sought for a decree of specific performance of the contract with regard to the renewal of the said lease on its expiry for the further period of 21 years. The suit is still pending. Now, my lord, if you file a suit after expiry seeking extension and confirmation of your right as a tenant or as sufferers or as holding over, my lord, you cannot fall back on those 21 years, 12 years judgment of continuing in possession without disturbance, because your entry into the property was permissive and your continuation in the property is not hostile.
No, during pendency of the suit, okay. Was any occupation charge or rent paid?
That is what the plaint says. I've shown your lordship the paragraph.
That is deposited in court.
That is the, your lordship need not go into the correctness of it. That's, as I say, your lordship will have to take the statements in the
Instead of paying to the
He could have.
landlord, that means they are also disputing the title. That means they are depositing in court.
No, I'll tell then kindly hold on, Millard. The plaintiffs are not added as party to the suit, although the plaintiffs were and still a necessary party thereto. The said purported title suit 1344 of 1994 was purported to have been filed by the defendant number 1 against Mihir Law, not as trustee on the plaintiff number 1, but in his individual capacity, and the renewal of the lease is sought for against the said Mihir Law, and not from home trust the plaintiff number 1 as owner of the suit. Millard, what is happening here is this. Mihir Law had created a trust. Now, Millard, I understand that Mihir Law was a person who, Millard, were happily signed documents in favor of very many people. He created a trust. So now, Millard, once the trust is created, the interest of trust goes with Mihir Law. Mihir Law was the settler to start with. Now, after his demise, you don't get any person to happily go on signing documents.
That is 2007.
Yes. So thereafter, what happens? The tenant, after expiry of his lease, is now trying to dispute the title of the trust. Therefore, he goes and files a suit against Mihir Law.
No, that is in 1994.
Yes. So therefore,
Mihir Law died in 2007. No, probably 2007, as per the previous paragraph.
I'll come. I just remember the date. I just stated here. I just read it.
Oh, this deed petition 2007.
Upon the date of Mihir Law, Mihir Law died.
In or about 2007, Mihir Law died. Yes, yes.
Yes.
2007.
2007. Now, thereafter, there are more interesting facts. The plaintiff state that in view of the then Millard, your lordship statement may not be 13 is not important.
Just a minute. Fixed matter. Just continue for 5 more minutes because I've fixed a matter at 12:30.
I have taken 15 minutes of his time.
Okay. So come on the next day. Yes, record an order. Mr. Gupta, learned counsel for the defendant applicant, has concluded his submissions. Mr. Datto, learned counsel for the plaintiff opposite party, submits, but could not conclude his submissions.
Next week.
Let this matter appear on. আচ্ছা 25 তারিখ 12:30টার সময় দেখুন তো কোনো ফিক্স ম্যাটার আছে কিনা।
Millard, 25th, 26th, 27th. Millard, 25th, 26th, 27th. I am examining a witness who is coming from Pune, and therefore the matters are fixed from 11:30 onwards before court.
Okay, then 12:30 it cannot be done.
No. It can be done at 2 o'clock.
আচ্ছা 25 তারিখে 3টের সময় দেখুন আছে কিছু আছে? 25 তারিখে। Okay, 20, I'm leaving aside the 25, 26 and 27.
Well, that will not carry on for more than an hour. So your lordship can fix any time in the second half, subject to business of the court.
28 কিন্তু চেম্বার ডে তো, চেম্বার ডেতে রাখা মুশকিল আছে। 28 তারিখে দুটোর সময় কি 3টের সময়?
সেপ্টেম্বরে নিয়ে যাও না, সেপ্টেম্বরে
দুটোর সময় নেই।
Second September. No. কিন্তু আমি 3rd থেকে নেই।
Okay, let it appear on 29/8/2025 within first 5 matters.
Very 28.
29.
29. Item number 1.
Your Lordship, item number 26. If your Lordship hears the 12:30 fixed matter,
Yes,
item
which
number
one?
26.
Item
26
and 27, my lord.
20,
6 and 27.
26 and 27. Yes.
Yes, my learned friend. My learned
Matter is fixed at what? Is it fixed matters? 26
No,
and 27?
no, my lord.
Not fixed.
Not fixed.
Then?
Your Lordship, my learned friend is just seeking
Adjournment.
adjournment for today, my lord. If my lord can be pleased to fix this matter anytime next week, we will
It is not yet,
complete.
this matter is not called 26 and 27.
No,
You are representing whom?
I'm representing the executors.
Okay, 26 and 27, not this week.
Grateful, my lord.
Fixed matter, item number 1.
Lord, Mr. Rupak Ghosh was submitting matter. Oh, yes.
reply
My lord, I had more or less completed, your lordship remembers. This is that Barik matter.
Is it a partnership matter or partition matter?
No, it's it's my lord, preliminary.
Oh, that partition matter. No, the other partnership matter also Mr. Ghosh is arguing.
Oh, there also Mr.
Oh,
Ghosh
there
is
also
there.
you are
Yes,
appearing.
yes, yes. my
We are opposing each other.
Yes. You have argued this on the.
Yes, I have argued threadbare. I have said that
Next
there
time
is
I
no...
want to be a friend, my lord, not a foe.
And so do I.
It's happening that in matters,
Anyway, this is a friendly fight.
No, Mr. Ghosh is always being there on the other side.
Now, my lord, just to refresh your lordship's memory, I had argued that we do not, in principle, stand in the way of an agreement between the parties for my lord, partition. But I had shown your lordship the prayers of the plaint. The prayers of the plaint are not for partition. Therefore, I have shown the prayers made by my learned friend in his application, which speaks about lot A, lot B, lot C. That cannot be done. Preliminary decree cannot be passed in a suit which is not for partition. It is not a suit for partition, as framed and as it stands today. Now, my lord, all we said was, yes, there was an agreement between the parties but there was no addendum, no meeting of minds as to which will be the properties under Schedule A, which will be the properties under Schedule B, and which will be the properties under Schedule C, because the minutes does not annex any of the schedules. Your lordship remembers, the schedule is only reproduced, so-called schedule is reproduced in my learned friend's application.
But in the meeting, it was not produced.
Not produced, not annexed to the meetings, and not produced before your lordship, not signed. Now, my lord, last, my lord, not the least, I had said that what is the contention? The contention is that, my lord, even if I have agreed to certain properties at a given point of time, 2022, and my lord, even before 2008, my lord, properties value or devalue in different rates. Now, my lord, today there is the valuations that have been produced by my learned friend. One is, I think, in 1998, one is in 1999, 97 and 98. More than 25, 27 years have passed. Those valuations cannot hold good. Today, my lord, certain properties may have appreciated more, certain properties may have appreciated less.
All we are saying is let there be a fair valuation of all the properties. And as per Mr. Chanchal Datto, one of the advocates of the Part C, my lord, clearly, my lord, parties also agreed that OLT money is to be decided between the parties. That minutes I have also shown your lordship, where he himself says that the valuation is very necessary because thereafter OLT money as to who is, if somebody gets 3 properties and somebody gets 5 properties and the valuation is differential, then my lord, the person who gets 3 properties in value less than 5 properties has to be compensated by way of OLT. Last, I had shown the will, which clearly says that the last residual clause is all 3 of my sons will get in equal shares. So equal shares means equal in value. And that equal in value can only be happening when there is a valuation. Those were more or less my submissions. My lord, Mr. Pradeep Datta, senior advocate appearing on behalf of the group C, had thereafter filed a supplementary affidavit. Now, my lord, I had sought for
So on the last occasion,
yes,
liberty was granted to defendant number 1B, 1F to file affidavit in opposition to the
my
supplementary
lord,
affidavit.
this is that option. May I file this?
Yes. Do you want to use any reply to this? With regard to, do you want to use any reply to the opposition?
My lord, they have stated a lot as against my client as well. My lord, I suppose finding a reply would again, my lord, procrastinate the matter. If I may just give a reply to what Mr. Rupak Ghosh has just submitted, my lord. Oh, bolbi tale. Bol tale. I do not know as to what they are going to say. Oh.
So this is only confined to the supplementary affidavit of the group 3 defendants.
Absolutely, madam.
No, you see, Mr. Ghosh.
Yes,
in your main application, affidavits are complete.
Yes,
that is GA23.
Yes.
But as you have used a supplementary affidavit, Mr. Rupak Ghosh has filed an affidavit in opposition. So he has almost concluded his submissions. So all that is needed is just a reply, affidavit in reply, and thereafter the written notes of arguments.
The verge of Mr. Rupak Ghosh's argument being completed, there has been again another affidavit. My lord,
supplementary has come at the verge of my arguments.
another affidavit.
That is filed by?
My lord, so this is a never-ending process.
Defendant number?
This is again filed by my lord.
Group 3.
Group C.
No, Group C.
Yes, my lord.
It is recorded as Group 3.
3 or C, whatever.
Okay.
Group
Because of the last occasion, 7th August, I granted opportunity to file opposition to the supplementary affidavit of Group C.
Yes,
I think that is your supplementary.
No, my lord, that is theirs.
Okay.
Group, that is there.
So,
Mr. Pradeep
that
Datta is
opportunity
appearing.
was granted on the last occasion, 7th August.
Yes.
So, you have not filed your affidavit in opposition to that supplementary affidavit.
They have filed an affidavit in opposition to that. My lord, I think my learned friend is now wanting to file a reply to this. If they are wanting to file a reply, my lord, I might as well
So
also
far, your
take time.
supplementary affidavit is concerned, I think the affidavit in opposition and reply, everything is complete. So, what your supplementary affidavit?
Yes, that
to
is
this
all complete.
GA23.
With regard to the latest supplementary affidavit which has been filed by Mr. Rupak Ghosh's client, now Mr. Pradeep Datta's client is wanting to file a reply to that. With regard to the latest one, this is
Latest supplementary affidavit.
Latest, that is the 14th of August 2025. There again, my lord, a new
আপনি নয় objection দেবেন আর নালে আর তো কিছু দেয়ার নেই যখন রিপ্লাই দিলে তো ওরা দেবে you cannot give a reply.
I know that.
Either they will give a reply or my lord we can go without a reply, but since he is asking for a reply,
Because it is not Mr. Ghosh's, senior Ghosh's application. It is there, but not his affidavit.
No,
because it is their affidavit.
their affidavit, but your lordship gave both me and Mr. Ghosh liberty to file an opposition.
Yes.
He has not filed an opposition.
Yes.
So he cannot file a reply to this.
No. There is no scope.
Yes.
No. I have also filed an opposition to that. That is there. Yes, that is there.
Then the matter ends there. Your part is over.
Let them file a reply. Let them file a reply.
He just filed a reply. That's all to my.
And you have almost concluded.
Yes. Oh no. Let him file a reply. I will finish in 10 minutes.
After they have filed the reply, you can conclude, and
10
all the learned advocates can file their written notes of arguments, compilations.
Yes, yes.
Only this, my lord, only this. Apropos my petition, my learned friend has made a submission.
Okay, you can reply also.
Yes, my lord.
Reply to everybody's.
Yes, because Mr. Rupak Ghosh's first submission has been that the petition as has been framed and the prayers have been prayed for cannot be maintainable inasmuch as it is not a suit for partition. As a result of which, my lord, my prayer for a preliminary decree being passed is not sustainable. To that, my lord, that's a pure question of law. May I address your lordship in the meantime till up to quarter past one?
It would be better after Mr. Rupak Ghosh concludes.
Yes.
And their affidavit in reply is considered.
your lordship,
You
please,
give
I
me a
was-
reply because it is your application. You have to give the reply.
Yes, I will.
So that opportunity you will get. And
No, but
thereafter, the
I was
written-
only saying that if your lordship was so pleased,
Anyway, it would be
as your
better.
lordship pleases, I do not quite come in the way.
Yes, record an order. Learned advocates for the parties are present. The supplementary affidavit of the affidavit in opposition to the supplementary affidavit of Group 3 defendants is filed by the defendant number 1B to 1F. Stop. As learned advocates representing the Group 3 defendants seeks to file affidavit in reply, the same prayer is allowed. Let affidavit in reply be filed on or before 25 okay 26/9/8/2025. Let this matter appear on 28 তারিখে দেখুন তো কোনো ফিক্সড আছে কিনা 28 তারিখে দুটোর সময়
28 তারিখ বলছেন চলছে।
আচ্ছা, let this matter appear on 29/8/2025 within first 5 matters.
Very well, madam.
ওটা কবে দেওয়া হয়েছে? The
First private car is better.
no, let the affidavit in reply be filed on or before 26/8/2025. Okay, 27/8/2025. This matter be fixed on 29/8/2025 Friday within first 5 matters.
Deeply obliged.
One thing, the payment was not made.
Yes, why the payment is not made? Earlier there is a direction.
My lord, your lordship on the last
Yes.
occasion was pleased to direct the payment to be made from the Axis Bank account.
Yes,
Thereafter,
I have
my
not
lord-
mentioned that.
No, your lordship will kindly mention that. I'll tell your lordship why. My lord, the defendant number 1 group is wanting to get the payment made from State Bank of India account. The State Bank of India account only has money which is being collected by my client who has been appointed as the special officer from rents belonging to Lot A and Lot B. But the amount which is lying in the Axis Bank belongs to all the 3 groups.
Okay.
So, my lord,
In terms of the earlier order, remuneration be paid to the joint administrator from the Axis Bank account.
I'm deeply obliged. Then, my lord, it is clear.
That is State Bank. But it has to be paid from State
Axis Bank account.
And Lot A and Lot B rents collected.
No, they're all saying no.
Let this matter
He's
appear
the
within
special
first 5
officer appointed
matters.
from court. He does it. He is the one who does it.
Already from Axis Bank.
No, it is not there in the order.
Yes, that your lordship will clarify.
Yes, yes.
That is with regard to the money which has been kept from sale of property. Sale of property belonging to all the 3 groups.
That is why I have clarified Axis Bank account.
I'm obliged.
Just bears with us. My lord, on instruction, I'm saying both Group C and Group 1 and Group 3 are saying that the State Bank account is the account which has money of all 3 branches.
My
It
lord,
is
he
not the Axis
person-
Bank.
My lord, may I then bring the orders?
Kindly bring the orders. I will also bring.
Okay, pay it without prejudice. You see, long time he is not.
The question is,
No, if it is there, permission will be granted to.
no,
to
that
adjust.
the other bank account only has the money of 2 of us.
No. That is exactly
If
the
it is
reverse.
found the opposite, then the direction.
Keeps it
the
tomorrow.
direction will be.
Well, kindly keeps it.
No, I will keep it on that particular day.
Just for this, well, I don't want to
No,
hold up the
no.
money of the special
So
officer.
it's better without prejudice you pay. If it is found the other way around, then it will be refunded through the other from the other bank.
Let
Do
him
it.
show. He says he has the orders. Let him show
It
your
will
lordship.
again take some time.
He has the orders, my lord.
Orders are
Okay,
there.
learned advocates are requested to sort out this matter with which bank the amount is lying.
Then again, the same, it will come back to the same position.
Yes, you sort out the matters
I
by
will go to
holding
Mr.
discussion.
Order to
দাদা এটা কোনো ব্যাপার না ঠিক আছে দেখা যায় যে
হ্যাঁ, আমি
এই
দেখে
bank
দিয়েছি।
Better if you are satisfied, you sort out the matter.
whichever bank account has 3 branches money, I am willing to give.
I have made it Axis Bank account, but you sort it out.
Don't, my lord, make anything.
Anyway, my lord,
Sit with this matter, sit with to sit and sort out the matter with regard to payment from Axis Bank account or State Bank account.
Appointed a special order to collect rental property. Well, kindly see this order. It's annexed to all. Kindly see this order, which is annexed to my affidavit that has been filed today. Court's order, where my lord the special officer has been appointed. Kindly see page 18.
No, you just played it out.
Yes, I am just reading out. Chandranath Barik substituted different number 2H. My learned friend, my learned friend's client, is appointed special officer to collect rents, issues, and profits, including areas accruing from the properties mentioned in serial numbers 1 to 26.
that is A and B, only for two groups. That is exactly what I'm saying.
Of GA such and such. He will open an account in his name of State Bank of India. So where is the other rents going? Where are the other rents going?
It is only with regard to lots A and B that he has been entitled to collect. That is what he's doing it.
So lot C also has to pay.
So that is exactly what I'm saying. The money lying in the Axis Bank is with regard to all the 3 lots. My lord, the property was sold much.
I've made it clear that
Axis Bank
not Axis, the learned advocates are to see and sort out the matter as to which account the amount should be paid. Whether Axis Bank or State Bank, that I've made it clear.
Yes, Axis Bank.
Axis Bank or State Bank.
My
Made
lord,
it all.
Again, with respect, my lord, my client has been appointed as a special officer for the purpose of collecting rents from certain properties. The serial number has
Okay,
been
how much is due and payable to you? 1 lakh? How much? Some amount is being paid. 31,000 was paid. How much is due and payable? 1 lakh? How much? Are you disputing the amount which is due and payable? Yes, Mr. Ghosh, are you disputing the amount which is total amount? So you're not disputing the amount.
Nobody is disputing the amount.
That is at present, how much is due and payable?
কত যাচ্ছে লাস্ট অর্ডারে কত বলেছেন যাচ্ছে বলুন বলুন
Last order.
হ্যাঁ what is that
Last order. That is, your lordship directed 25,000.
কোন অ্যাকাউন্ট থেকে সেটা বলো
1,500 GMs. So 1,500 GMs, it can be paid from any accounts.
Have no problem in payment. We are not disputing and we are saying
That can be adjusted. So let it be paid from Axis Bank account, subject to adjustment
I'll
subsequently.
tell you, Lordship, Axis Bank account holds the money of a property which has already been sold. My lord, that a major part of the money has already been distributed among these 3 groups in 1/3 proportion. What is left out of that sale proceeds is in the Axis Bank.
So 1,500
Yes,
is
my
a
lord.
very meager amount.
It is. My lord, so this Axis Bank money is belonging to all the 3 groups. And this amount of money that is being collected by my client is with regard to collection of properties which are allotted in A and B. So if it is given from State Bank, then C group will not be paying any portion. That is exactly the reason why I'm saying that the money should come from Axis Bank. If your lordship so feels, your lordship will direct that if there is any anomaly with regard to this money being paid from Axis Bank, it will be adjusted in the due
last
course.
portionটা একটু পড়ুন তো কি আছে একটু গোটা অর্ডারটাই পড়ুন
সেটা অন্য কথা কিন্তু যদি ওয়ান প্রপার্টি 1 to
3জনকেই তো দিতে হবে
1 to 26 যদি শুধু আমাদের প্রপার্টি হয় 1 আর 2 এ তাহলে সি 3 কেন স্কট ফ্রি যাচ্ছে তো আমি তো ওয়ান আমি তো বোঝে না কিছু উল্টো পাল্টা
Bas. Axis Bank account of 1,500 GMs. Next, in the event there is any anomaly with regard to the payment of remuneration from Axis Bank account, the same may be submitted on the next day for necessary rectification of the anomaly.
Obliged, my lord. I think this will, at least for the moment.
I'm so sorry. We are all
পরে
sorry.
যেটা আছে স্টেট ব্যাংক আর অ্যাক্সিস ব্যাংক যেটা ওটা কেটে দেবেন।
Trivial issue, my lord. We are sorry, my lord. We are troubling your lordship.
Anyway,
Trivial
please,
issue.
We have to act as per
But
the
the special
instructions.
officer has to be paid.
Yes,
There is
for this meager amounts,
No,
do not
that's fine, lord.
create disputes.
He is there, he has to be.
Item number 28.
Your Lordships, I am appearing on behalf of the respondent number 5, Your Lordship.
I'm appearing for the respondent plaintiff, Lord. 20.
Yes.
I'm appearing for plaintiff, Lord. Your Lordship has been pleased to fix this matter for hearing of the application, Lord. So there is an affidavit of defendant, Lord. If your Lordship can have a look at that, so that affidavit really supports my case, Lord. In fact, there can be a decree on judgment on ambition, Lord.
Okay.
If your Lordship looks at the affidavit
is this?
in opposition, Lord, which has been affirmed, Lord, on 25th September 2012, Lord, to my application, Lord.
Is GA1 is whose application? GA1
It
of
is my application, Lord.
Okay. What have you prayed for in this application?
Lord, there is already an order of injunction.
Yes.
And, Lord, status quo regarding the property, Lord.
Yes.
The property is under the position of the symbolic position of the joint receivers, Lord, by
Yes.
the interim order. Lord, this matter was pending for quite some time, my lord, and Lord, this has appeared before my lord, and Lord, this has been appearing for now for some time, my lord. Your lordship has been kind enough to extend the interim orders, my lord, also.
So you are representing the defendant.
No, I am representing plaintiff, my lord. I am for the plaintiff.
So let us fix this matter and you conclude the hearing on the next day.
Very well. Your eyes will lordship, please.
Yes. Learned advocates for the parties are present. Let this matter appear on
Sometime in September, my lord. It can wait for some time, my lord.
9/9/2025 for further hearing. The interim order granted earlier stands extended for a period of 5 weeks or till further orders is earlier.
I'm deeply obliged. I'm deeply obliged.
Item number 30.
Lordship, item 30, GA6 is my application seeking to be added as a party in the plaint. On the last occasion, by an order dated 30th July, my lord had directed us to serve a notice intimating of the next date of hearing to the plaintiff.
Yes.
Lordship, we
You are
have
representing
served the
different
notice.
numbers,
The
1 to
plaintiff
5.
have also acknowledged the service. Lordship, I've handed over a was done
The
by
application
mail.
for addition of parties.
Addition of parties. Lordship, the plaintiff is the necessary. The pleadings are completed, my lords. They filed their opposition. We have also given their reply. Lordship sees after the half the page, they've also replied saying noted thanks. Lordship, so they've also acknowledged the letter. Now, if they are not appearing as your Lordship deems
You have
fit.
to have the learned advocate also.
Learned advocate, my lord. That was the, because they've already completed
Their affidavits.
their affidavits. Their opposition, my reply, it's on record, my lords.
Okay,
But-
let me see the application.
Lordship. Or if your Lordship wants, can keeps it, whatever is convenient to Lordship, I can place the application, my lords. Lordship, GA6, Lordship sees the praise from the notice of motion.
Yes. What is this suit for?
Lordship, I'll say. Lordship, there is a premises. Now, the plaintiff over here is a tenant under the premises.
Yes.
I am admittedly a subtenant under the plaintiff, my lords. Now, I do not have the entire access to the cost papers, but I was paying rent to the plaintiff herein, and there were disputes which went up to the
Okay,
NCLT.
you are paying rent to the plaintiff.
The plaintiff, admittedly as a subtenant, my lords. Now, suddenly, lordship, what
Plaintiff has filed the suit for what? Eviction of the defendant.
lordship, I do not have the entire cost papers. I have, that is one of my prayers, that the entire set of cost papers be given.
So let
What
me
I
see.
have been able to ascertain is that the
I am for the plaintiff.
lordship, the plaintiffs,
Yes. So this application is to be heard and decided.
lordship.
So when can you come ready?
Your lordship can keep it after a week's. You can give me a week's time. You can do it.
So please come ready.
Lordship.
Yes, record and order. Learned advocates for the parties are present. As the affidavits in this matter is complete, let this matter appear on (27/8, 2025).
Your lordship, instead of 27, can it be on 29th?
29th is a Friday. Actually, it may be difficult.
Lordship is all.
In the next week, on 1st of September week. First, second, third,
Okay,
fourth.
1/9/2025.
So 1/9, lordship will come. Grateful. Grateful.
Yes, হয়ে গেছে?
We'll come back after.
Yes.